Hi, everybody. So for the past, I don't even know, 6 hours, I've been summarizing all these documents that were filed today. There's 3 from the prosecution and 2 from the defense obviously, we're talking about the Delphi murder. So I am going to get right to it because I have like 49 different PowerPoint slides. So people wondering, that's Naples, Italy behind me. I'm going to share my PowerPoints. As always, this should be about Abby and Libby and hopefully getting justice for them. Hi to everybody. I'm going to make this full screen. Let me see. I'll give you guys a minute to join. For some reason, I can't make it full screen, but you should be able to see that. So as I said, today, January 29th, the prosecution filed a verified information of contemptuous conduct, a motion to compel discovery, and a response to motion to transfer. The defense filed a motion to disqualify Gull again, and Richard Allen has an affidavit that was filed related to that motion to disqualify. So Rick's affidavit is 22 pages long. So I'm going to do the prosecution stuff first and then save the defense stuff, the longest stuff for the end. So starting with the verified information of contemptuous conduct filed by, whoops, Tom messed up. Anyway, this is, yeah, obviously copied and pasted and didn't look. I rushed to do this, so let's have some sympathy for Tom. All right, the summary of this is McClelland wants Gull to know about the contemptuous conduct by, every time I write Baldwin, or sorry, B/R, it means Baldwin and Rosie, Rick's defense lawyers. So McClelland wants Gull to know about the contemptuous conduct by Baldwin and Rosie pursuant to IC, so that's, I believe, Indiana code, whatever you see there, and for Baldwin and Rosie to appear in court to defend themselves against these allegations and be held in direct contempt for violation of this court's orders. Give me 5 seconds. So, number 1, Baldwin and Rosie were appointed November 14th, 2022. 2, November 22nd, 2022, there was a hearing on preliminary matters and Nick McClelland filed motion for gag order. Number 3, in chambers, Baldwin and Rosie refused to agree with the gag order because they had no intentions of discussing the case in public. Just for anybody who's joining now, if you've read all of these, literally, I'm going to be summarizing them for probably over the next hour. So you can either chat with the people in the chat room politely or go take a hike. I don't know. I'm going to, after each document, I will look at the chat room. Hopefully. All right. Number 4, December 1st, 2022. The defense issued a press release and presented evidence to prove Rick's innocence. Number 5, the release had comments with a likelihood of prejudicing an adjudicative proceeding in this matter. No idea what that means. Number 6, December 2nd, 2022. Gull approved the gag order, which prevented attorneys themselves or through any intermediary from commenting on the case. Gull reminded Baldwin and Rosie about rules of professional conduct. Number 7, December 2022, Andy Baldwin violated the gag order by emailing Brandon Woodhouse containing an outline of discovery, including the names of juvenile witnesses. So some people say I'm biased against the defense, and I just call it like I see it. And as these slides go on, I will pretty much call out everybody. But now I'm going to call out the prosecutor McClelland because he's complaining about releasing the names of juvenile witnesses. And I've noticed that over the past year, we know that the first PCA came out and it had a bunch of blank spaces for the witness names. And then there was something, I think, in April where they released the PCA again, but it had some different wording and it had the initials of the juvenile witnesses. And then they had a third version of the PCA released at some other filing by McClelland, and it included the full names of the juvenile witnesses. So If I'm going to call out somebody, I'm going to call out everybody, including myself. Yeah, just a reminder, even though these say filed by the defense, this section is the prosecution. All right, here we go. Continuing on. Number 8, Baldwin and Rosie failed to notify Gull or McClelland about that email to Woodhouse and asked Woodhouse. So Baldwin asked Woodhouse to delete the email. Woodhouse said that Baldwin showed up when Woodhouse was at the Carroll County Jail and had Woodhouse get in touch with his girlfriend, I think, and find the computer or the phone that contained Baldwin's erroneous email to Woodhouse, and had Baldwin meet Woodhouse's girlfriend to make sure that email was deleted. So that's what Woodhouse said. Not sure it's true, but it's kind of shady if Baldwin did that. Anyway, number 9, the state discovered this leak after Woodhouse made a YouTube video in March of 2023. So not for a few months until the state found out about this little boo-boo that Baldwin made. Woodhouse sent the info to several people, which violated the gag order that relates back to Baldwin's email to Brandon Woodhouse. Number 10, February 13th, 2023, the state filed a motion requesting a protective order governing discovery, which means evidence, to prevent the defense from disseminating evidence to people outside the case and to the public. Number 11, February 17th, Gull granted the motion with very restrictive rules to prevent evidence being shared with anyone not involved in the case. 12, October 2023, the state was made aware by the families of the victims that crime scene photos were leaked. Indiana State Police investigated, and it was obvious the leaked photos came from the defense. On September 18th, we all know the Franks memo was released, and it described the crime scene in gory graphic detail and attached exhibits that were side-by-side photos the defense created, and the photos of the crime scene the defense had altered. These photos were the photos that were leaked to the public. Number 13, a podcaster said he got the photos from someone who got them from Robert Fortson, who got them from Mitch Westerman, who is tied to the defense. Just a note, as I went through over the past 6 hours summarizing the stuff, they were so long that I had to try and condense it to make it like easily readable and understandable for all of us. So I did not purposely edit these to make either the prosecution look good or the defense look bad. So just that note. Number 14, October 10th, Baldwin stated on a call with all parties that Mitch stopped by his office to visit, snuck in his conference room where all the discovery was unsecured, and took photos of the crime scene pics. Baldwin said it was without his permission and the pics were stolen. Ironically, this was hours after investigators spoke to Robert Fortson, who's the guy who committed suicide, and determined Westerman leaked the photos, and he was the connection to the defense. As I've said previously, it's why was Westerman even at Baldwin's office? As we're about to find out, Baldwin was telling Westerman details about the case, and I've showed previously that it seems like the rules indicate that Baldwin was supposed to have Westerman or anybody else that he shared this evidence with sign some kind of form that had to be issued to Judge Gull. I'm surprised that McClelland did not even reference that aspect of this in this filing. Number 15, Indiana State Police revealed Westerman previously worked with Baldwin and was a person Baldwin trusted. Baldwin told Indiana State Police he gave Westerman and another civilian the Franks memo to review, which contained protected discovery. Westerman gave Fortson the photos, who passed them on to individuals who distributed them throughout the internet. As some of you know, I get triggered by grammatical errors, and I complain about the defense's spelling and grammar, and even McClelland is including this apostrophe in Franks. It's based on a case where the guy's last name was Franks, and you're not supposed to include the apostrophe. So I know the defense and prosecution are watching. Please stop triggering me with your random apostrophes. 16. Oh my gosh, they just all switched over to watch Greg Hughes. Number 16, go get yelled at by Gray instead of by me. Number 16, October 12th, 2023, Rosie submitted a letter to Gull admitting he and Baldwin agreed to store the discovery in Baldwin's conference room and Westerman had access and took the photos. Rosie admitted it was negligent on the part of the defense to allow Mitch Westerman alone in the office and accepted responsibility for a lapse in security, admitting to the court they are in indirect contempt of the court's orders. Number 17, October 18th, the next day, Westerman's affidavit confirmed he went in Baldwin's conference room and took pictures of evidence without Baldwin's permission. I don't know. I have conflicting views about this. Obviously, Baldwin was unaware. And it seems like obviously not just any person could walk into his office building and just walk past the conference room and go in there and take photos. So I understand that Baldwin isn't like totally complicit in this, but as has been stated, like despite that, these photos were taken and distributed to the public. Number 18. Indiana State Police has messages between Fortson, and previously I've only referred to this guy, Robert Fortson, as the guy who committed suicide, because sometimes I've seen on like Facebook when there'd be various suspects in this case, people on Facebook are brutal with their messages to these suspects and family members. So I was just trying to protect like the wife of him, of Fortson, from people leaving horrible messages on her Facebook. I'm sure she's obviously devastated, she and her teenage daughter. But from now on, I will refer to him by his last name, Fortson. So just to reiterate, Fortson is the guy who committed suicide, who had these photos. I believe he committed suicide on October, I'm not sure, around the 10th or so. ISP has messages between Fortson and another person that showed that Fortson had detailed real-time knowledge about when evidence was submitted to the defense and the contents of that evidence for weeks before the photos were leaked. Fortson also knew the actions defense took in trial preparation, leading law enforcement to believe this was not a one-time act of one person, but a consistent leak of information and discovery. Westerman would get info and give it to Fortson, who distributed it to other individuals, which obviously, I mean, later on, I'll say that the defense has some valid complaints about Gull, but I mean, this is a violation. 19, Indiana State Police tried to interview Mitch Westerman and Robert Fortson, but they declined. 20, shortly after investigators tried to interview Robert Fortson, he took his own life. Shortly before his death, he expressed concerns about the investigation into the discovery leak and stated to someone that if he just came clean, all this would go away. Obviously, Westerman, he got out on like $250 bail. I don't know if he lost his job, but he obviously looks like he looks bad. But I mean, I don't know why this guy ended his life. Apparently, Westerman and Fortson may have met in the military. And some people are saying that Fortson kind of went against the trust of Westerman and like broke that military brotherhood trust. And maybe Fortson was so upset about that partially. That is what kind of led him to be so distraught. 21, a search warrant of Westerman's iCloud revealed screenshots of conversations between Mitch Westerman and Baldwin candidly discussing Rick's case, the court, the state, displaying a free flow of information that is protected by the gag order and the order protecting discovery. Anybody just joining, this is the verified information of contemptuous conduct. It was filed by McClelland, the prosecution. I made a mistake up here by the defense. 22, the defense failed to secure evidence, including crime scene photos, which were distributed to the public in violation of the court order, and the disclosure was ongoing. 23, October 19th, Baldwin's attorney, David Hennessy, suggested both attorneys be sanctioned for their actions, but those sanctions have yet to be addressed. 24, the families of the victims have been harmed and re-victimized by the leak of the crime scene photos. 25, this is the last slide on this one, this filing. The defense press release and the 2 occasions of leaked information show a trend by Baldwin and Rosie of not being completely honest with the court, violating the gag order, and failing to comply with the protective order on discovery. The state asked the court to issue a rule to show cause order and set a hearing for Baldwin and Rosie to appear and show cause, if there be any, why they should not be held in contempt by this court. Thoughts on that, you guys? Up next is the state's motion to compel discovery, but I will look at your comments real quick. Hi, Sinbad Sailor. Based on today's ridiculous filing, which one? I'm guessing Westerman is still calling the shots on Tweedledum and Tweedledee's litigation strategy. So Sinbad Sailor is not a fan of Baldwin and Rosie. There's a lot of people in here who have various opinions, so just please be respectful, although maybe calling them Tweedledee and Tweedledum is not respectful. Hi, this Mel. I just don't understand this leak. Westerman leaking to Robert Fortson, who then unalives. And who did it help? Not the defense, that's for sure. Interesting military connection with Odinism, just saying. Well, it seems like Westerman, apparently Baldwin's, one of his strategies for defense is asking a lot of people for their input, apparently including former employees. So Westerman knew that Fortson was interested in the Delphi case, so he was telling his friend. And then he did not, I guess Westerman did not know that Fortson was then like sharing them with online sleuths. Let that be a lesson to never share anything with an online sleuth. We still have 5 more filings to go through. Hi, Luna Ray. Seems a bit desperate considering the recent Supreme Court decision. I don't know. I mean, I think it's a valid concern. It's been ongoing by the defense, even though I have said previously, obviously Baldwin's email to Woodhouse, he started to write BRA for Brad Rosie and it autofilled to Brandon Woodhouse, which showed that as of early December 2022, Baldwin was communicating with Brandon Woodhouse because Woodhouse had previously sued Carroll County Sheriff for like bad jail conditions and treatment in the Carroll County Jail. Sinbad Sailor says, Fortson committed suicide, assumed he was going to be dishonorably discharged. His 20-year military career was about to be destroyed. I know that he worked on I think a military base or something, but he was a civilian employee, not, I guess, I don't know how all that works though. Hi, Adam. Thank you. Any news on Mitch Westerman? He has a trial coming up. So he pled not guilty. I'm not sure when that trial is. All right, I'm going to do one more and then I'll get back to filing number 2 out of 5. If you're just joining, I have like 48 total PowerPoint slides, but we just went through about 5. Luna Ray, this is the last one. Luna Ray says, it was an outline for God's sake, nothing to call home about. Yeah, but still, it was evidence that was supposed to be protected by Baldwin, and he did not protect it at the most basic level. All right, get Tom off the screen, and let's show a new filing. Let's see if I messed up this one also. Get Luna Bell or Luna Ray. So, some of this text is kind of small for you guys to see, so forgive me that. I know I'm so boring, like reading this stuff, but there's a bunch of other options to go watch live chats, I guess. Anyway, so January 27th, which was, I guess, on Saturday, state's motion to compel discovery filed by the prosecution. The summary is, McClellan requests the court order the defendant to comply with the Indiana Supreme Court Rules of Criminal Procedure, Rule 2.5, and Carroll County Local Court Rules, and states the following. So this is trying to get evidence from the defense. 1, charges were filed October 28th, 2022. Number 2, court granted a motion by the defense for a discovery deadline, ordering the state to produce discovery by November 1st of last year. Number 3, the state complied. And so McClellan is saying here, by last November, he handed over all the evidence to the defense. If you did not watch my 7-hour and 5-minute Frank's memo, I did repeatedly call out the prosecution and law enforcement for taking so long to hand over evidence. It just seems like they were so disorganized, which, I mean, I said, if they're so disorganized handing over the evidence, how were they even like doing a proper investigation before they even looked into Rick? Anyway, number 4, Carroll County local court rules direct that all discovery is to be exchanged between the state and defense automatically and continuously. Number 5, effective January 1st of this year, the Indiana Supreme Court issued rules of criminal procedure stating the parties must share information without court involvement. Subsection C, disclosure by the defense, states that within 30 days after the prosecutor's disclosure, the defense must furnish the state with the following material. A, the name, I edited some of these just for brevity. A, the names and last known addresses of persons whom the defense intends to call as witnesses with their statements. B, any books, papers, documents, photographs, or tangible objects the defense intends to use as evidence. C, any reports or statements of experts, including results of physical or mental examinations, end of scientific tests, experiments, or comparisons that may be used at a hearing or trial. So it seems like here McClelland is asking for mental examinations, but twice previously he's asked Gull to force the defense, or at least Westville, to hand over Rick's mental health and medical records, and twice Gull has denied McClelland's request. I know some people, including Baldwin and Rosie, say that Gull is prejudiced and biased in helping out the prosecution, but she has denied at least those 4 different motions twice each for mental health and medical records for Rick. So it seems like even now, McClelland wants those mental health examinations, which I do think he should have access to them if the defense is saying that Rick is having all these mental issues, which included causing him to call his wife on April 3rd and supposedly admitting that he killed Abby and Libby. I know everybody gets freaked out by anybody suggesting that's what he said, but at first the defense said Rick called his wife and confessed because he was having mental issues because Westville is so horrible, but then they changed it later saying they made up that fake quote saying he called because the Odinist guards were saying they were going to kill his family if he did not call his wife and confess, which if you looked at the footnote, which some people did not because they actually still believe that quote, the defense said Rick Allen never said that quote. The defense must disclose any statutory defense in writing by the statutory deadline, or if there is no statutory deadline, within a reasonable time. Continued. So we're going on the state's motion to compel discovery. Continued. Number 6, to date, the defense has neither turned over any discovery nor a list of expert witnesses they intend to call at trial or pre-trial hearing. That ain't good. But obviously they've been out of commission for the past over 2 months. From like October 12th, Gull said to cease work on Rick's case, and they were not reinstated until recently. So I'm sure they're ready to send it all tomorrow. Number 7, despite requests by the state for the defense to disclose any exhibits they intend to use in depositions, defense has failed to provide the state with those exhibits prior to the commencement of depositions. Like, this isn't cool, to be honest. I mean, I'm sure they have some stuff that they should be turning over, but as the defense will show later, it took the state a hell of a long time to hand their stuff over too. 8, the state believes the defense intends to introduce expert testimony, exhibits, and evidence at the pretrial hearings and at trial. Number 9, the state intends to depose all defense expert witnesses and or other witnesses in preparation for pretrial hearings and jury trial, but cannot do so without full discovery disclosure. Nick McClelland requests an order to compel discovery by the defense within a reasonable time, not to exceed 30 days, and for all other just and proper relief. So that's the third one of, the second of 3 by the prosecution. I'm sweating. I had to take off my whatever sweatshirt. Sinbad So what is this? Is this new PowerPoint presentation available for download? No, it's my live chats. It's my live chat's PowerPoint slide that has, or PowerPoint file that has 187 PowerPoint slides. I'm crying. I have tears in my eyes, but I'm not crying. Let's see what you guys are saying. This is a good point. This Mel, the last time they filed, Gull, sorry, I tried to like translate these. The last time I believe the prosecution filed, Gull told them the next time she was going to approve the prosecution's next motion because they kept opening the door by stating his mental health was suffering because prison. That's a good reminder there. Hi, devoted to Mariah. This is the first time I've seen you, and if we are Lambily, what took you so long? Anyway, people are like, what are you talking about? Anyway. Oh my gosh. Stick around or don't stick around. Let's see. I'm trying to find like one other opposing thing. Hi, Lala. He is CJK. He admits on his blog that a defense investigator would routinely speak with him and take notes. It's also the only place I can see the antique car is mentioned. I don't know. Let me see. Sorry, how far? I'm only 5 minutes behind. All right, DNA King is here. He's a defense lawyer, so he can guide me in the right direction. Criminal law. The prosecution has a weak case and must distract defense counsel with everything they can throw at the wall. It's a fairly common tactic for prosecutors who have no real evidence. Hi, Gino. Thank you for gifting memberships. They're kind of lame. My memberships, I only do like a member live chat on the third Saturday of every month, but I will be doing some more member live chats as like more stuff like comes out. And I'm working on a new Delphi video, a deep dive, which I said I'm not doing anymore, but this one's only taken about 2 weeks. People are going to be triggered, so it should be out by next weekend. All right, I'm going back to being off screen, and we're going on to the third of the prosecutions. Oops, sorry, darling, I need to take that off. Let's see. All right, this is the third one that was filed by the defense today, and then I'm going to get into the really long ones about the defense did. So the prosecution filed the state's response to defense's motion for transfer of Rick. So Rick was briefly represented by Labrado and Scremin, who are public defenders. They filed a motion to transfer Rick out of Wabash. So Rick was at Westville. He finally got moved to Wabash, and then there's more complaints about how far that is from the attorneys, which I agree they should not have to drive 3.5 hours one way. Okay, so my summary is the state has no preference where Rick is held pre-trial, but believes it is in the best interest of the case to inform the court of the exaggerations and inaccuracies outlined in the defense's third motion to transfer. So yeah, this is the third time that Rick's defense attorneys have tried to get him moved, I guess, closer to their offices and in a county jail, since typically people who are arrested in America are supposed to go to a jail and only go to a prison if they're convicted. You guys know all this backstory. Anyway, number one, charges are filed against Rick October 28th for counts of murder. 2, the Carroll County Sheriff requested Rick be transferred to Indiana Department of Corrections for safekeeping. Number 3, Rick was transferred to Westville on November 3rd of 2022. Number 4, defense filed an emergency motion to modify the safekeeping order on April 5th, 2023, which was denied. We all know what happened 2 days before when Rick apparently called his wife. Number 5, defense filed motion to reconsider and request for due process hearing on May 3rd, 2023. Number 6, that hearing was held and the court denied the motion to modify the safekeeping order, stating the allegations by the defense were not supported by the evidence presented which was presented by the Westville warden, John Gallipo. Number 7, the court made a finding that is reasonable and necessary to house Rick at Westville to ensure his safety and prevent serious bodily injury to himself. So Rick has apparently made suicidal comments at, I'm not sure if he did it first at Carroll County Jail within the first few days, but he definitely supposedly did when he got to Westville, and also when he recently went to Wabash in December. Number 8, defense filed verified motion for immediate transfer of custody, alleging additional mistreatment of Rick at Westville. Number 9, the court stated the defense's assertions were factually inaccurate and refuted by the evidence. Number 10, Indiana Department of Correction transferred Rick to Wabash Prison. Technically, it's called the Wabash Correctional Facility. Number 11, when I write L and S, that means Labrado and Scremin, who were Rick's temporary attorneys. So Labrado and Scremin filed the third motion to transfer. Number 12, the state has no opinion where Rick is housed, as long as he is kept safe. However, the state believes it is imperative for the court to have accurate information in order to make its decision, which is lacking from the defense's motion to transfer. Number 13, Labrado and Scremin reference the emergency motion to modify safekeeping order filed by prior counsel, aka Baldwin and Rosie, and how they find the allegations in that motion meritorious. Number 14, that the motion has already been litigated at length, and the court found the allegations outlined in that motion were without merit after the June 15th hearing with the warden. Number 15, counsel references a letter written by inmate Robert Baston stating Rick is being mistreated as fact to be taken as true. I think most of you have heard about this Robert Baston guy who's had a long history of complaining about prison conditions. Baldwin, I'm not saying that he's wrong what he's saying about Rick, but we'll get to what he says in a second. Baldwin and Rosie subpoenaed Baston to testify at the June 15th hearing, but he refused to leave his cell, whereas previously he had talked to the defense, and when it came time to go from Westville to the courthouse on June 15th, Baston refused to leave his cell. The state has later on, the defense is going to kind of call out Judge Gull for how she handled this. Stay tuned. I'll get to that in like 2 hours. The state has documented Baston's history in prior hearings and filings, and his allegations are not reliable evidence provided as sworn testimony, nor has he been subjected to cross-examination. 16, counsel for Rick reasserts he is being mistreated by guards at Westville who practice Odinism. 17, this issue has been addressed in a previous motion and was found to not have merit, and the motion was denied. 18, that defense then make the allegation Rick was denied recreational time and showers at Westville. So in the latest one, Labrado and Scremin said that these Odinist guards would walk up to Rick's cell, because I guess there's a schedule, unlike what Baldwin and Rosie said in that first motion to modify safekeeping order, where the guards will come up to the cell and say, do you want your scheduled shower? Do you want your scheduled recreation time? But apparently what Rick told his attorneys was that the guards would ask that question while they were moving their heads back and side to side, indicating like, don't say yes, you should say no, so we don't have to waste our time taking you. As a lot of you know, Rick's cell is under video surveillance for every second of the day. There's no microphone, but I would imagine there has to be video of this showing whether or not these guards are in fact moving their head side to side. If they are, I do think they should be fired for doing that to inmates. However, I don't know. I don't believe some of this other stuff that the defense has accused these two guards of. Number 18, that defense then make, I already said that, sorry. 19, Rick has never been denied recreational time or showers at Westville. Number 20, when Rick was moved from Westville to Wabash, he made statements about committing suicide, which was a surprise to me. I mean, I think they may have referenced it a few weeks ago, but why is he still talking about suicide? And why do people want him to go to a county jail where they only have mental health professionals like once a week? compared to almost full-time at prisons. As a precaution, he was examined by mental health professionals and, they determined that he should not be given recreational time until they can be sure that he would not hurt himself. Once he was off suicide watch, his recreational time resumed. 12. Labrado and Scremin complained the check-in process at Wabash is too burdensome and time-consuming. 22. The state saw video of their visit, and the check-in lasted about 23 minutes, not the nearly 1 hour alleged in the pleadings. The wait time was extended on this date due to a power outage. It seems like there's always issues with these prisons, these jails. 23. The facility typically does not allow face-to-face visits, but did accommodate Labrado and Scremin and set up Rick in a special room seated behind a door that was see-through that had a slot where documents, papers, or whatever could be passed. See photographs attached as State's Exhibit 1 and 2. I actually forgot to look at this, so I'm going to slow my roll and I'm going to show you guys this. So when I first read that, when the motion to transfer Rick, the third one, I was like, why are they putting him in a kitchen cell where the defense lawyers can only look through a slot and they cannot show and share evidence with Rick? So I imagined it being like a solid door, but all right, let me see. State's response. I'm going to show you guys this real quick. Here we go. So you can kind of see in there, but still, I just don't understand why. Let me just one other page here. So this is the slot here. There's just 2 photos. Actually, there's a person in there. Is there? Let me see. I guess they're showing an example if that's a person, which that's ridiculous to me that Rick is in shackles and he has to be behind this door. Like if there's guards there, well, actually they said the guards can't be there because they can't overhear what Rick is saying to his attorneys. I don't know what the right answer is, to be honest. But I don't think he should be in shackles. If people in jail are allowed to not be in handcuffs or shackles around their ankles when they meet with their attorneys, just because Rick is in prison, he shouldn't have to have like this different treatment. All right, where are we here? All right, I just did that. 24. A surveillance camera was present in the room that records movement only and no audio. The only thing recorded was when Labrado and Scremin entered the room and when they left the room. I don't know about that. Anyway, to the state's knowledge, any jail that attorneys visit to meet with their clients is video recorded or monitored in some fashion. That is for the protection of the attorney and the defendant. And from what I've heard, to make sure that the attorneys are not passing any contraband to the defendant or inmates. 25, that neither attorney brought a computer with them to provide the defendant with review of video or audio discovery, even after Department of Corrections made accommodations for them to do so. So they were complaining that they could not share evidence with Rick, but the prosecution is saying they didn't even really bring at least a computer to show videos to Rick. I don't know what they'd be showing him. 26, defense were told by Department of Corrections that if they needed anything additional to meet with their client, to just ask and accommodations would be made for them. 27, each request Labrado and Scremin have made of Wabash has been granted. 28, the allegations the defense outline are exaggerated and misleading. They were able to meet Rick, show him discovery in whatever format, and meet with him in an effective way. I don't agree with that. This seems to be more of motion about convenience for them instead of zealous representation of Rick. I disagree with that. I mean, I think he should be closer to his attorneys, not like a 10-hour trip, round trip every time to see him in person. But there's some interesting stuff next. 29, the state pulled the records from Wabash, spoke to legal counsel from Indiana Department of Corrections, and reviewed the video from Wabash and the allegations put forward by the defense are inaccurate. 30, Rick has a tablet in his cell that he can communicate with his counsel at any time and has had it since he has been there. 31, since the motion has been filed by the defense, the Department of Corrections has set up video conferencing so Rick can now meet with his counsel via video. And I know some people just freaked out, like, oh, the prosecution is going to be watching it and stuff like that, and the state and the prison. I don't know. 32, Rick has commissary in his cell, but other inmates do not. I know the commissary is when an inmate can buy, like, maybe better food and clothing and some other stuff. So I'm not exactly sure what exactly they're referring to for commissary and why some other inmates do not. 33, Rick is being treated, sorry, I almost choked on that. Rick is being treated far better than any other inmate in the Department of Corrections. I don't agree with that. I mean, I have my issues with both sides here, but I would not say that, from what I've seen at least. 34, the state spoke to the sheriff from Adams County. Just before I review these next two. So in the motion to transfer by Librato and Scremin, they said that Wabash was so far away, they wanted Rick moved to a county jail nearby. So they live in Allen County. So they asked that Rick be moved to Adams or Allen County jail. Obviously, Baldwin and Rosie are in different locations, and Rosie has previously asked that Rick be moved to Cass County jail, which is, he said, I think a 2-minute walk from his office. So if he wants to see Rick, he could just go across the street. However, the sheriff of Cass County, he testified, I think he was even at the June 15th hearing, he said Rick's cell would be smaller than it is at Westville. And also, if he is making suicidal comments, he would never be allowed to leave his cell, even for rec time. As I just previously said, they don't allow, apparently, anybody who makes suicidal comments to leave their cell. Also, the Cass County sheriff said they only have intermittent mental health services, which, if Rick is saying he's suicidal and having these other mental health issues, like, I don't know. I want Rick to be getting all the services that he deserves, but I'm just concerned, like, what's going to happen when he goes to county jail? Are people really thinking that he's going to be, I don't know, just like making friends and he's going to be so happy? I don't know. 34, the state spoke to the sheriff from Adams County, and he is not willing to accept Rick because they don't have space, accommodations, or the mental health professionals available to address Rick's mental health needs. Well, why is he commenting on Rick's mental health needs if McClelland does not have access to Rick's mental health records? I don't know. 35, the state spoke to the sheriff from Allen County, and he is willing to accept Rick in his facility, but only at the expense of Carroll County. However, the Allen County jail is currently overcrowded and would have to make special accommodations to house Rick, and they do not have face-to-face visits. All visits are done via video, including attorney visits. I just don't understand how, like, these jails and prisons don't seem to have opportunities for people to meet their, like, a room dedicated for meeting your family and your attorneys and conjugal visits. 36. Hopefully nobody heard what I just said. 36. Don't rewind. 36. Defense continues to make unfounded accusations supported by insufficient proof. 37. The Carroll County Sheriff's Department does not have the manpower to transport Rick or the room to house Rick in a manner that ensures his safety. Yeah, I've heard Carroll County Jail is an SHI hole. Number 38. Carroll County Jail, they're building a new one. I think it's going to be ready. I don't know. I have a bad memory. I read it yesterday, but I forget. They're getting jail cells, I think, March of this year. But maybe by the end of this year, they might have a new Carroll County Jail. So in case any of you criminals from Delphi want a new place to stay, maybe you can live stream from the new county jail. 38. Carroll County Jail does not have mental health counselors or counseling to address any suicidal concerns that have been ongoing. 39. For the third time, the colorful, dramatic language used by the defense is an attempt to curry public favor for Rick and try this matter in the public eye instead of the courtroom. 40. The state has no opinion on where Rick should be housed, but the state does take offense to defense once again filing a motion that is full of inaccuracies and allegations not supported by sufficient evidence. 41. I think we're getting close to the end of this one. 41. The state has no objection to Rick being moved to a facility within the Department of Corrections, but the court has already addressed that issue in previous orders. 42. Defense is consuming the limited resources of this office and this court with repetitive motions that lack any factual basis. Well, if they moved Rick to a county jail a long time ago, we wouldn't have these repeated requests. All right, that was the end of that. Let me look and see what you guys are arguing about. Where are we here? Hi, Bees. Did anyone really believe Baldwin and Rosie were going to do pro bono, which they would not get paid? I hope not. It's called posturing. They were not going to bankrupt themselves. I don't know. Well, now they're reinstated, so it's I don't know what's going to happen with. It's so ridiculous to me that the judge and the attorneys are fighting. It's like, I mean, I understand that to get justice for Abby and Libby, that Rick needs to have a judge that is not biased, and also he needs to have attorneys that are competent. But it's just crazy to me. Hi, Danielle. Jamie Hicks got a free membership. Peace and love, y'all. Hi, Kevin. Aloha. It's raining in Honolulu. We'll need good luck finding 12 jurors. I'm sure they can find 12 people who have never used a computer. Oh my gosh. I just keep it honest. Hi, Steffa. Tom is a real salesman for his channel. He said my memberships are lame. Yeah, so after this, I have like maybe 25 more PowerPoint slides for the 2 defense motions from today, which has some interesting stuff in it. You're one of the very few people who watched it. Mel, this Mel. I loved your Frank's, used an apostrophe in Frank's motion deep dive, by the way. I found your attempts to be unbiased, to be credible, and you gave some details about the early days of the case that were really relevant for us newbies, right? I'm glad you got something out of it. Luna wants to know who wrote this. Tom summarized it, but McClelland wrote it. I'll do one more and then I'll get on to the defense stuff. Sally says, hi, Sally. So 4 attorneys, Baldwin, Rosie, Librato, and Scremin, were all wrong about his treatment at the facilities. No way. I agree. I think they were right about some stuff, but I think they exaggerate about other stuff. I mean, I was really surprised that Baldwin and Rosie like flat out accused the 2 Westville guards of like being involved in or having some kind of like motivation based on being Odinist and like connected to the murder somehow. And people say, well, the Frank's memo was based on this Click report, like these 3 guys, Click, Ferenczi, and Murphy. And that's true, but the parts accusing the Odinist guards or the Odinite guards, which the defense does not learn the difference. That was not in law enforcement reports. Hi, Diana. Oops. Devoted to Mariah says, at this point, put Rick wherever they want. Just get him to court alive and on time. End of sound mind and body. I agree with you. Elusive Chanteuse. I agree, but as I said before, like, is Rick gonna just his whole demeanor is going to change as soon as he goes to county jail? I don't know. All right, one more, and then I'm going back to this. Hi, USA Libertarian. Spending all day driving makes meeting with him effectively impossible. That is why McClellan likes it. So Rick can't help his defense team. Well, now they can use video, although is that I know people are going to say they're like watching everything he says. Hi, Humanimal. He wears a suicide smock. It is usual procedure for someone who has expressed suicidal thoughts or other thoughts of self-harm. Other inmates wear, oh, sorry, other inmates were shackled. Garrett Kurtz, Ron Logan, Brian Chadwell, contrary to propaganda. All right, I need to get back to my PowerPoint slides. But good morning or afternoon in Australia. All right, well, now we're moving on to the two things from the defense. This affidavit of Richard Allen was 22 pages long. So unfortunately, I tried my best to summarize it, but it's just really long. So I don't know, bear with me. If you read it, you can just leave. All right. This is going to take probably the next 20 minutes, unfortunately. So January 28th, affidavit of Richard Allen. He did not write this, just FYI. He signed it, but he didn't write it. Filed by the defense. My summary is, number one, judge. Oh, so wait, let me just, this is based on this other motion, which actually I should probably read that first. Yeah, let me do that. Please stand by. Affidavit. So the defense filed a verified motion to disqualify. So I'm going to read this first, and then I'll read Rick's. So again, verified motion to disqualify Judge Gull. They're trying, Walden and Rosie are trying again to get rid of her. Number one, motion for disqualification prevents Gull from deciding on any matters until a ruling on the disqualification motion occurs. So who knows how long this is going to go back and forth. Number two, pursuant to Indiana Crime Rule of Procedure, quote, sorry, the state or defendant may request a change of venue from the judge only for bias or prejudice. The motion must be accompanied by an affidavit signed by the defendant or prosecuting attorney. The court must grant the request if the facts recited in the affidavit support a rational inference of bias or prejudice. Number three, Rule 2.11 of the Indiana Code of Judicial Conduct requires a judge to disqualify herself when the judge's impartiality might reasonably be questioned. Would an objective person have a reasonable basis doubting the judge's impartiality? Number 4 and 5, they were kind of repetitive, so I didn't really summarize them. Number 6, the accused has a federal due process right to an unbiased judge. 7, there is no recognizable legal rationale which supports Gull continuing to preside over this case. The actions and rulings of Gull will be scrutinized through the lens of Gull's error in severing Rick's attorney-client relationship with his chosen lawyer. So because she removed Walden and Rosie, everything she decides on going forward, people are going to like question, or at least some people will question her motives. 8, and just another note for people who don't know, Baldwin, Rick's attorney, who's saying that Gull is biased against him, has taken on another murder suspect that is being ruled on in Judge Gull's court. So is he going to file a motion in that case also? A woman, I guess, killed her husband. Is he going to say that that can't be tried in Gull's court because Gull doesn't like him? 8, the preamble to the Code of Judicial Conduct provides that judges, quote, should aspire at all times to conduct that ensures the greatest possible public confidence in their independence, impartiality, integrity, and competence, end quote. Number 9, this court has already interfered with one of the most sacred concepts in our Constitution, the relationship between attorney and client. If the Indiana Supreme Court concluded that Gull wrongfully denied Rick of the attorneys of his choosing, wouldn't then an objective person have a reasonable belief that she, Judge Frances C. Gull, is biased and prejudiced towards Rick? I would say yes, but at the same time, they're totally ignoring all of her reasons that built up over 11 months before she did that. 10, Gull should recuse herself. 11, Gull continuing to preside over this case necessitates that the following questions be asked. A, will Gull's continued involvement create built-in reversible error in the event Rick is convicted of any of the charged crimes? B, will all future rulings of the court, when they refer to the court, it essentially means Gull, Judge Gull. Will all future rulings of the court be viewed by the defense as being tainted with bias, prejudice, and a lack of impartiality? C, will the public be able to maintain any sense of confidence that Gull is unbiased and impartial? D, can Gull process any information and or legal arguments offered by Baldwin and Rosie, knowing that she has already made an extrajudicial finding that both attorneys have demonstrated gross negligence and gross incompetence? E, does Gull have some ulterior reason or motivation driving her unwillingness to recuse herself from this case? F, do the practical benefits of recusal far outweigh the inherent risks of Gull remaining on the case, especially as it relates to the likelihood of protracted and expensive litigation throughout the remainder of this case and in the appellate courts if a conviction occurs? 12, accompanying this motion is the affidavit of Richard Allen, which I'll get to in a minute. This says affidavit of Richard Allen continued, certification of Allen's attorneys, and here it has the signatures of Baldwin, Rosie, and then Baldwin. And when I saw Baldwin's signature, I thought like Great Adventure should make a roller coaster ride based on like all these loop-de-loops. Anyway, where are we here? End of January slides. All right. Now I'm going back up to this 22-page affidavit by Rick. Oh, okay, good. Here we go. Oops. All right, so this is the affidavit of Richard Allen. Again, this was 22 pages, and I tried to summarize it as best I could, but it was very wordy. And I didn't want to just delete a lot of stuff, so I'm going to do this for maybe 20 minutes or so. Number 1, and this is the last of the 5 filings. Judge Gull interfered with Richard Allen's attorney-client relationship. So this document are all the reasons why Baldwin and Rosie want Judge Gull to be removed from the case. And they do have quite a few good points, which I agreed with, and some of them I think they're crazy. All right. 1, Judge Gull interfered with Richard Allen's attorney-client relationship. On October 12th, Gull instructed Baldwin and Rosie to cease work which denied him timely and effective representation, and occurred 1 week before the October 19th hearing. 1 week later, on October 19th, Gull staged the premeditated removal of Baldwin and Rosie with cameras in the courtroom for the first time, and she prepared claims of grossly negligent and incompetent actions. 2, Gull publicly and on the record disparaged defendant Allen's chosen attorneys. The week before the October 19th hearing, Baldwin and Rosie asked Gull what to expect. Baldwin and Rosie knew since October 10th, when they had this conference call with Gull, Baldwin, Rosie, and McClelland on October 10th. So during that call, they knew that Gull was inclined to have Baldwin and Rosie removed at the request of Prosecutor McClelland, which Baldwin and Rosie are like, we're not incompetent, but we still haven't figured out how to spell Nick McClelland's last name. Anyway, was inclined to Baldwin and Rosie removed at the request of Prosecutor McClelland before any hearing had taken place, before researching the issue, or even having any meaningful chance to consider the request. So I agree with Baldwin and Rosie they should have been given more notice of exactly what was going to happen. However, on the other hand, it's like, why not go out there and like stick up for yourself and say, well, Gull, you didn't even tell us what this was going to be about, and like shame her in public. And the only reason it was on TV or broadcast was because Baldwin and Rosie submitted a motion for broadcasting order saying, we want the public to see all these hearings and to be able to see like what goes on and be transparent until it was going to be where Baldwin and Rosie were going to be called out. And essentially, it seems like what I read before, that the prosecution filed for contemptuous whatever behavior by Baldwin and Rosie with those ongoing leaks, that was the stuff that they were going to talk about, like Jerry Holman from Indiana State Police and other people were going to get on the stand and say October 19th, like this ongoing stuff that Baldwin was talking to Westerman. They had the screenshots between Westerman and Baldwin. So when Baldwin knew that stuff, he was like, where's the back door? Between the October 10th phone call and October 19th, Gull prepared a statement as her basis for grossly negligence and incompetence. Gull later added Baldwin and Rosie also violated the rules of professional conduct. They added a footnote. Gull's appellate attorney, I think they're referring to Gutwein from, if you saw the Supreme Court, I believe the guy with the last name Gutwein is Gull's appellate attorney. He acknowledged to the Indiana Supreme Court that Baldwin and Rosie were, quote, very experienced and highly competent, end quote, lawyers in all other respects, except for their alleged incompetencies and gross negligent acts in this case. Like, oh my gosh. The contrasting facts are hard to reconcile. There is a basis of prejudice because Gull formed this opinion and claimed in chambers, which means her office for anybody. Some people from around the world don't speak English, so I try to explain some of these concepts in words. And claimed in chambers that she is finding gross incompetence. A judge that has predetermined an attorney is grossly negligent and incompetent has developed a bias towards that attorney. Yeah, but I mean, if they're repeatedly making mistakes, what is she going to do? Just ignore it? Gull telling Rick she has, quote unquote, grave concerns about Baldwin and Rosie representing him provides a rational inference of bias and prejudice. Gull, for the first time ever, allowing cameras, knowing her plan to ambush the defense and how cameras in the courtroom would impact the attorneys psychologically as they tried to process their options, provides a rational inference of bias and prejudice. I mean, she finally granted their request and then they were complaining about it. 3, Judge Gull violated defendant Allen's due process rights. On October 19th, Gull ambushed appointed counsel with a planned Hobson's choice designed to coerce withdrawals or suffer a public shaming at the expense of Rick and be removed, or withdraw in the face of compromising Rick's defense strategy. Baldwin and Rosie requested clarification as to the topics and or motions at the October 19th hearing, but Gull gave no notice of her plan to force withdrawals or remove them, thus denying counsel the opportunity to adequately refute her accusations. Gull's failure to offer the basic due process of the law creates a rational inference of bias or prejudice towards Rick and Baldwin and Rosie. I agree. She should have given more notice to Baldwin and Rosie and maybe scheduled a hearing later on where they knew exactly what to prepare for. Gull's complaint was more about not having control over Baldwin and Rosie rather than any legitimate concerns they engaged in conduct that compromised Rick's defense. Gull cited a number of concerns, none of which formed a basis for the removal under Indiana law. Until the in-chambers hearing on October 19th, other than the evidence leak, Gull never mentioned the other items were worthy of disqualification. Baldwin and Rosie could not have prepared to refute Gull's belief that Rosie's filing of a tort claim notice to protect his client's rights was one reason that she thought the defense should be disqualified. Gull provided no preview of why she wanted to disqualify Baldwin and Rosie, other than the leak, and never told the defense she already made up her mind to remove them. The majority of topics Gull raised for removal were a surprise to Baldwin and Rosie. What happened in Chambers was a violation of Rick's and his attorney's due process rights, which the Indiana Supreme Court agreed with. The highly public litigation between Gull and Rick, Baldwin, and Rosie provides a rational inference of bias and prejudice. Number 4, Judge Gull engaged in critical stage proceedings in defendant's absence. On October 19th, Gull conducted critical stage proceedings in Chambers outside the presence of Rick, even though he was available, placing Baldwin and Rosie in an ethical dilemma and creating a public record outside the presence of Rick. This ignored any sense of due process and violated the following rules. Number 5, I think there's like 25 of these things, so buckle up. Number 5, Judge Gull failed to maintain impartiality and fairness. Gull engaged in a planned, forced resignation of the defense in her chambers on October 19th when she referenced Baldwin and Rosie's pleadings that contained quote-unquote inaccuracies and falsehoods in the emergency motion to modify the safekeeping order that was denied by Gull, which was prejudicial to Rick's defense. Gull's belief Baldwin and Rosie would provide false pleadings to the court, thereby questioning their integrity, exhibits a rational inference of bias and prejudice. Well, hold up, because I agree that there were some questionable things said by the Rosie and Baldwin. So this is my stuff. I inserted a few prior slides because the defense is saying, oh, we never lied. And here's October 19th in the chamber. This is when they're saying, Rosie said, do you want to make a record with this? I mean, I think it's appropriate that the court let Rick speak into the record his thoughts, unless the court, aka Judge Gull, just accepts that as notice that those are his opinions. So this was after Baldwin and Rosie went out to talk to Rick. So they met, Baldwin, Rosie, and McClellan met with Gull around 12:30. She was saying, like, I want you guys out of here. They went to talk to Rick separately, and they come back, and Rosie said, like, Rick, I think he said that Rick does not want Baldwin and Rosie to go off his case. So Gull said, well, you wouldn't lie to me about that. And Rosie says, I would not lie to you about anything, which was that a lie or not? Because at the June 15th hearing, there is no transcript, which I'll get to that later. And Baldwin and Rosie still do not have the June 15th hearing transcript, which I agree with him. That's absolutely ridiculous and unacceptable. But WRTV is a local website, and they had somebody in the courtroom on June 15th. It says Rosie was the only one from the defense who presented that day. Allen's attorney says that they want Allen to be treated like any other pretrial defendant. They argued he has no privacy at Westville, and that they, Baldwin and Rosie, have spent all of their time trying to get him housed in better conditions, so they have not been able to focus on the case and their defense. So is that a true statement or a lie from Rosie? Because they're saying for 7 months, Baldwin and Rosie focused on getting Rick Allen out of Westville and nothing else. When we know from the September 18th, Frank's manifesto, at that time, April 3rd, the defense was fully aware of the Odenite involvement in the murders, but law enforcement would likely not have known that the defense was aware of the Odenite involvement, which could explain why they felt comfortable wearing patches. That was a reference to the guards. Continued on, this decision has been painfully and emotionally difficult for Rick's defense team, as defense counsel recognized that while the defense took the necessary time to review the discovery to establish the Odenist links both to the murders and to the Westville Correctional Facility, defense counsel was also aware that Rick would remain in his hellhole at Westville, subject to the cruelty of these two sergeants, the Odenite guards, or Odenist guards, whatever you want to call them. Odenite's a mineral. And perhaps other Odenite corrections officers. This was especially painful at the June 15th hearing to transport Rick to Cass County, as defense counsel, aka Rosie, knew at that time of the links between the murders and Odenism and Westville. Unfortunately, defense counsel needed additional time to fully understand and verify the facts before leveling such accusations. This is the reason that the defense tactically decided to keep its knowledge to itself rather than reveal that knowledge in open court at the hearing. I understand that that is like a strategy and they did not want to reveal that, but why is Rosie saying they spent all their time just trying to get Rick out of Westville when that does not seem to be true? And also he said they never lied, which at the June 15th hearing, I'm not going to go through all these, but there's at least 5 things that, I don't know if you want to call them lies or exaggerations, but if anybody's watching back, pause here if you want to read it. Pause here if you want to read it. I'm getting back to this affidavit from Rick. Number 6, Judge Gull demonstrated bias toward the prosecution. Leading up to October 19th, Gull, Baldwin and Rosie, and McClelland participated in a call to discuss matters associated with the dissemination of crime scene photos. McClelland first uttered the word disqualification. After a very brief discussion, Gull communicated to the parties she was inclined to grant the request without having conducted even the most informal of hearings, without having considered any single piece of evidence, and without consulting with Rick. Gull's conduct of quickly siding with the prosecution on an off-the-record phone call on a matter of such high importance, i.e., illegally kicking off lawyers who have spent thousands of hours on the case and would be prepared for the January 24th trial date, demonstrates a rational inference of bias against Rick and runs afoul of Rule 2.3 of the CJC. As I said before, it seems like it was 11 months since the November the December the press release after they knew that there's going to be a gag order. So it wasn't like so quick as they're seeming to show. 7, Judge Gull made public misrepresentations on the record. After Gull's removal of Baldwin and Rosie, she addressed those in attendance and the public through a camera authorized by Gull, which requested by the defense, broadcasting to the public and potential jury pool. Well, they wanted all these hearings broadcast, which would have been seen by a potential jury pool. So, I mean, I get some of their points, but on other things, they're just like, seriously? In pertinent part, Gull said, quote, we've had an unexpected turn of events, ladies and gentlemen. Earlier this afternoon, the defense attorneys have withdrawn their representation of Mr. Allen. Clearly, this is outside of our control, end quote. Remember that day when that happened? Everybody's like, holy crap. When referring to the events in chambers, these words are untruths, as the withdrawals of Baldwin and Rosie were exactly what Gull pre-planned, and her words intended to disguise her in-chambers actions which forced their resignation. Gull knew her actions were wrong, as later she tried to conceal what happened when Rick's original action lawyers, that's, I guess, Mark Lehman, that guy who argued for the Indiana Supreme Court. So when Rick's original action lawyers attempted to obtain a transcript, Gull's staff refused access as confidential. Rick was denied his right to the transcript of a hearing wherein he was not present and wherein his lawyers were effectively severed from him without his consent. In order to review what happened in chambers, Rick's counsel were forced to request the Indiana Supreme Court to order Gull to release the transcript, which they did. Gull's attempt to deny Rick's lawyers the transcript provides a rational inference of bias against Rick and his attorneys. I agree that it was kind of ridiculous that they had to ask the Supreme Court to provide it. I think Gull replied at some point. I forget if she said the court reporter was slow. She did not say that. I'm not sure if she gave some kind of excuse or reason why it even got to the point where the attorneys for Rick had to contact the Supreme Court to say, we can't even get this in chambers transcript. Gull's claims the events were unexpected and out of the court's control are in conflict with the Rule 1.2 of the CJC and support recusal pursuant to this other rule. 8, Judge Gull engaged in ex parte communications. On October 30th, Baldwin and Rosie filed as pro bono, which means essentially free, attorneys, and the next morning appeared in court to carry out the representation of Rick. Gull refused to allow them to carry out the representation of their client. This included communicating by text message to Gull's chosen replacement attorneys, Scremin and Labrado, prior to the start of the hearing. This also included engaging in an in-chambers conference with Labrado and Scremin and McClelland, while Baldwin and Rosie remained in the courtroom with Rick. Gull severed the attorney-client relationship for a second time without seeking the opinion and/or permission from Rick, which was prejudicial to his defense, violated his rights, and impaired any public transparency in the actions of the judiciary. I mean, this is like, there's some certain issues in this case that they're just like dragging on and on. They need to have Gull or whoever, because honestly, at this point, I don't think, I mean, some of these accusations by the defense, I think they're totally warranted, and Gull basically screwed up and isn't following procedures. So I have like no reason that I have to have Judge Gull on the case. I'm just, at this point, I'm like, okay, just replace her with a special judge, like maybe a former Indiana Supreme Court judge, which some of them do these special judge cases. But I'm like, let's just hear from Rick. Gull or whoever the judge is in the next few weeks or months needs to ask Rick, what do you want? Do you want Baldwin and Rosie as your attorneys? Like, have him speak up, say, what is going on in prison? How are you being abused by these guards? How do you feel like you're being mistreated just in general as a pre-trial detainee who's supposed to be in jail? Like, let's hear from Rick. It's odd to me that Robert Baston is writing letters to Judge Gull saying, oh, Rick is being mistreated, yet I've never heard of a letter being written by Rick to Judge Gull saying, please help me, I'm being mistreated. It's just coming from these various defense motions, which, I mean, let's hear from Rick. I'm not saying that in any bad way. I mean, he deserves to have a voice in his treatment, and whatever, if he's being mistreated, needs to be addressed. 9, Gull denied Rick his Sixth Amendment right to counsel and speedy trial. Gull denied Rick's right to counsel when she forced their resignation, and Baldwin and Rosie filed to be pro bono attorneys per Rick's request. Rick's intentions were to file a speedy trial motion and secure his previously scheduled jury trial date of January 8th, 2024. Fun fact, this trial should probably be over by now. Gull prevented this because she didn't let Rick have the attorneys of his choosing, which derailed any strategy Rick, Baldwin, and Rosie developed to challenge the merits of the state's charging information. Gull's actions were prejudicial to Rick, denying his basic constitutional right to choice of counsel and a speedy trial, which was also prejudicial to Rick because he was returned to the same maximum security unit where he was unfairly detained and experienced both mental and physical deterioration for nearly a year prior to Gull's Sixth Amendment violation. This one's really small, sorry. 10, Gull changed her ruling in a prior order when Rosie and Baldwin were reinstated. Gull received the Franks memo on September 18th, who could forget, a date immortalized in history, a work of art, but took no action for over 4 months, which I agree, that's kind of whack, Jack. She offered her chosen public defenders, Librato and Scremin, which Baldwin and Rosie were also chosen by Gull on November 14th, 2022. So Gull offered Librato and Scremin the opportunity for a hearing while they were representing Rick. This is evident from her November 1st order, wherein she offered up the following invitation, quote, court notes 2 pending motions, the motion to suppress and the motion for Frank's hearing, and will await a report from attorneys Scremin and Librato and prosecuting attorney McClelland regarding hearing dates, end quote. So here we go. The court then memorialized this invitation to pursue these motions in a minute entry reflected in the chronological case summary, I think is CCS, on November 2nd. November 14th, Gull issued an additional minute entry, again inviting Librato and Scremin to set a hearing on the pleadings. The minute entry reads as follows, quote, if defendants' new counsel inform the court they intend to pursue the Franks motion, the court will schedule a hearing, end quote. Now, I agree that that's kind of suspicious, that wording. I don't know if Gull meant something else or what, because is she saying that, I don't know what she's saying. There needs to be some kind of response to this from Gull also, not just the state. 2 days after Baldwin and Rosie were reinstated, Gull issued an order denying a hearing on the Franks motion and denying a motion in limine regarding the admission of ballistics evidence by the state. Gull's opinion lacks any serious legal and factual analysis on such an important issue, which begs the question of whether Gull actually engaged in any meaningful review of the memo and exhibits. Well, I think she said there was 1,500 pages, and I don't know. I don't think Baldwin and Rosie even read the Franks memo, so why do they expect Gull to? The timing of the ruling and lack of legal/factual analysis provides a rational inference of bias or prejudice against Rick, and most notably, Gull offering her chosen replacement attorneys the opportunity for a hearing on the pending motions while denying Baldwin and Rosie the same opportunity creates a rational inference of personal bias against Rick, Baldwin, and Rosie. I agree. If that was her intent, saying if Lobrato and Scremin want a Franks hearing, that she's just going to give it to them, that's not cool or acceptable that she would do that and deny it to Baldwin or Rosie. Having said that, I don't know if you, I guess this Mel watched my 7-hour Franks manifesto video. And I showed that, from my opinion, the point of the Franks hearing is to say, if the supposed lies by Tony Liggett in the affidavit were removed, would Judge Diener have approved the search warrant of Rick's house on October 13th, 2022? So those supposed lies included and omissions, included witness 4 saying she saw a bridge guy, but he looked like he was a 20-year-old with moppy hair or something like that. Also, they did not include witness 4's description of the car's CPS at around 215 as being from the 1960s, which also Baldwin and Rosie in the Franks manifesto left out the 210 and 228 witnesses who said it was not from the 1960s. So they were essentially doing the same exact thing that they're accusing Liggett of. Also, Liggett's other lies were the 357 driver, 3:57 p.m. Apparently in 2017, she said she saw a guy at 3:57 walking towards CPS. And in 2017, she may have said his jacket was, I think it said tan or beige or maybe light brown, not dark blue. But Liggett wrote in the search warrant that she said it was blue. She also said that she saw Libby's screenshot, and that was the man that she saw walking on the street. So I don't understand how those two things can be true at the same time. Wrapping up this thought, I feel like even without those supposed lies or omissions, there still was enough stuff in that search warrant to have Diener sign off on the search warrant. There's a video at 1:27 p.m. with a car that supposedly matches Rick's car headed towards CPS. I don't know. I'm not going into all those things. I watch my 7-hour video if you want. I don't want to ever see it again. I think this means 11. Judge Gull discredited. Is anybody still here? I don't know. I'm not watching the chat. I'm all by myself. Number 11, Judge Gull. Let me take a drink. Judge Gull discredited Defendant Allen's defense strategy. November 14th, 2023. Gull issued an order that acknowledged Rick's filing of a motion for Frank's hearing, memorandum in support, and accompanying documentation. These documents had been filed on or about September 18th. Nearly 2 months later, Gull, having taken no action on Rick's pleading, invited Lobrato and Scremin to either, quote, adopt those pleadings or make their own, end quote. Implicit within Gull's verbiage is what appears to be her attempt to empower her chosen replacements to abandon a material aspect of Rick's defense strategy. If there is any debate about the court's intentions, Gull's order and the language therein creates the impression that the court is skeptical of Allen's defense strategy. I wrote this part, which is essentially like, I think they're referring to that Odinist killed Abby and Libby, which again came from 3 law enforcement officers. but not part of the Unified Command, which is like the top 6 or 7 guys, investigators, thereby prejudicing the totality of his defense. Accordingly, Judge Gull violated Rule 2.3 of the CJC. I was so busy summarizing this stuff, I didn't look at these specific rules. That's up to all of you to do on your free time. 12. Gull committed violations of the Access to Court Records Act, which I agree with this one. Gull did remove and seal or order the removal of defense pleadings from the chronological case summary in violation of the Indiana Supreme Court's administrative rules. Those pleadings include the Franks motion, the Franks memorandum, 3 affidavits, which I'm glad to see that defense learned how to spell Gallipo. In the Franks memo, they spelled it Gallipo, and I think Gallipo, so they spelled it twice, different ways and wrong. Filed, blah, blah, blah. The affidavit of an accused leaker, Mitch Westerman, and an affidavit signed by a defense investigator, whatever her name is, and incorporated in the 3rd request for transfer. By secreting pleadings from the docket without following the ACR rules, which ACR I think means access to court records, Gull allowed violations of public access. Because those acts have shielded documents, these actions demonstrate a lack of impartiality and fairness in violation of this rule. This footnote says, quote, "A judge shall comply with the law, including the Code of Judicial Conduct." And this other one, "A judge shall uphold and apply the law and shall perform all duties of judicial office fairly and impartially." 13. Judge Gull engaged in additional violations of the Access to Court Records Act. Well, they have a lot of complaints about her. And as I've said, I do agree with most of these. And I'm fine if she goes bye-bye. Rick's original motion to disqualify Gull was filed October 25th. On October 27th, Gull issued an order noting Rosie's withdrawal, albeit forced, from the case and struck from the record substantive pleadings filed by Rick, aka his attorneys. Any authority Gull had to strike the substantive pleadings from the record stemmed from Gull's reversible error, terminating the attorney-client relationship between Rick and Rosie despite Rick's objection. Gull's conduct demonstrates Gull's inability to remain impartial to Rick and demonstrates Gull has engaged in judicial conduct, which undermines all public confidence in the independence, integrity, and impartiality of the court in violation of that rule. 14. As I said, I think there's like maybe 25 of these. Gull failed to address her administrative duties. Walden and Rosie submitted their first invoices in May of 2023. So what was that, 6 months after they started? I don't know why it took so long. They had to follow up repeatedly and were not paid until September. I agree, this is like really unacceptable, but I just don't know what Gull's response would be, why it would take so long for her to approve these invoices. This is an ongoing issue with delays and non-communication from Gull and her staff, and some invoices still remain unpaid. The court's conduct is in violation of this rule. On August 8th of last summer, Rick's attorneys requested the transcript from the June 15th hearing. And that hearing was about the request that Rick be moved out of Westville for reasons important to the defense. So they wanted this transcript for important reasons. The defense still has not received it. Gull's failure to provide that transcript is another example of Gull's contempt of the defense. I totally agree that it's beyond ridiculous that all this time later, they do not have this transcript. 15. Gull failed to protect the accused. Rick's unique and unusually burdensome detention circumstances have been a concern of his defense for a long time, and Rosie informed Gull of a reasonable solution, which was the Cass County jail across from his office, from Rosie's office. Gull declined to take precautionary action, so on April 5th, 2023, the defense filed an emergency motion to modify the safekeeping order, but Gull didn't set a hearing until June 15th. I've said previously, like, the defense said that they were working on moving Rick, spending all their time moving Rick, but they didn't file this thing until April 5th, which is like, whatever, 5 or 6 months after they started representing Rick they don't file something officially until 2 days after he supposedly calls his wife and confesses, which to me, that's kind of shady. But then later, it did say that as early as I think February 8th, Rosie had emailed Gull suggesting that Cass County Jail was an option, which she declined, which I think I get to that, I don't know, in a few more slides. Westville inmate Robert Baston filed a letter corroborating some of the concerns, and the defense subpoenaed him to the June 15th hearing. On June 15th, Gull, in her chambers, said she released Carroll County from the sheriff's office from executing the subpoena on Baston due to Baston's resistance. So Baston, I guess he said he would go to court, and then on June 15th, he was like, yeah, I'm not going. The hearing was held, and Gull ruled on July 19th, denying to move Rick. So Gull and or her staff chose to communicate with Tobe Lesenby concerning Baston's unwillingness to attend, but Baston had no choice but to appear, and Carroll County had no choice but to honor the subpoena filed by the defense and transport Baston to that June 15th hearing. The proper method to deal with the situation would have been for Gull to alert both sides, so prosecution and defense, about the problem and then conduct a hearing about it on the record, which I agree, that does seem to me maybe be the better option. Instead, Gull opted to leave the defense completely out of the equation and issued an off-record ruling advising the Carroll County Sheriff and Westville to leave the inmate Baston at Westville, thereby ignoring the valid subpoena served by the defense for a witness that was expected to support the defense assertions concerning Rick's treatment at Westville. As I said before, yeah, that's great to have Robert Baston show up at the June 15th hearing and say Rick is being mistreated. Where the hell is Rick getting on the stand and saying, I'm being mistreated? That's like, I agree with some of the stuff that the defense says, but if Rick is being mistreated, then speak up. What's this? In summary, this is still the same number. We're almost to the end. Sorry if everybody's like gone. Anyway, in summary of this number, there's still more to go. Gull released a material defense witness from a properly served subpoena and then claimed the defense team failed to meet its burden of proving up the allegations in its emergency motion when it was Gull that prevented a defense witness from testifying. Gull's actions were prejudicial to Rick in that her actions usurped Rick's ability to prosecute his own emergency motion, which is otherwise known as the refusal of compulsory process. Gull's behavior exhibits a rational inference of bias and prejudice against Rick and his attorneys, blah, blah, blah. 16. Gull's continued and ongoing failure to protect the accused, aka Rick. Gull exhibited a lack of concern about and taken no action to protect the physical and mental health of Rick. On two different occasions, Gull has been asked to order the removal of Rick from Westville and place him in a less restrictive and healthier environment, as he is a pre-trial detainee. Gull denied both attempts, stating the allegations offered up by the defense counsel were untrue. Gull accused Rosie of misrepresenting truths about Rick's detention circumstances and used this as support for Gull's findings that defense counsel engaged in gross negligence in their representation of Rick. Well, at one point, Gull said, it's not my decision, whatever the Indiana Department of Corrections wants to do, they can, but I understand that they're saying, well, Gull, why don't you order that Rick gets moved to Cass County? But here he's saying Rosie or whatever, actually this is Rick's affidavit, but it's essentially Rosie and Baldwin saying, move Rick to a place that's less restrictive. So what is that? He's going to hang out with other inmates and healthier. What's healthier? Summary of this one. Rick's replacement attorneys, Librato and Scremin, filed a third motion and addressed ongoing connections between Odinists employed by the Indiana Department of Corrections. Former counsel Scremin offered a photo of one guard, one of these Odinist guards, who was so bold as to tattoo an Odinite symbol on his face while knowing that his Odinite connections had been previously called into question by the defense in formal pleadings. I just can't believe that the defense didn't hear everybody complaining that they used the word Odinite, which is a mineral and not Odinist. Rick continues to be detained, i.e. shackled like Hannibal Lecter, which is misspelled, unnecessarily and has now been moved to a facility 233 miles from replacement counsel attorneys Scremin and Labrato, both last names are misspelled. Gull continues to take no action to protect Rick, but has jurisdiction of Rick's detention circumstances. It would be entirely appropriate for Gull to err on the side of caution and engage in remedial measures to ensure Rick is being housed under humane circumstances for a pre-trial detainee and order the detention of Rick in a facility near his court-appointed attorney so they would have the simple convenience of communicating with him in person and under reasonable conditions. Rosie arranged for the Cass County Jail a 2-minute walk from his office. Footnote, this exchange occurred in an email from Rosie to Gull and Cass County Sheriff Schroeder on February 8th, 2023, so almost a year ago. I don't know. I think they should have a hearing again, which already this guy, the sheriff, said, okay, Rick's cell is going to be smaller at Cass County than at Westville. He can't have face-to-face visits with his wife and family if he's making suicidal comments. He can't have rec time if he's making suicidal comments. So he's going to be in a cell all day long in a cell that's smaller than Westville. So how is that going to make him happier? I don't know. I really do want Rick to be in the best location, but I just don't know what the answer is. So if he's like suicidal, Cass County said they only have intermittent mental health professionals. So what happens if Rick, I don't want to say goes crazy, and there's nobody there to help him? Gull denied it and sided with the Carroll County Sheriff's Department due to its confusing claim that the sheriff would have difficulty transporting Rick 20 minutes from Logansport to Delphi when it was taking much longer to transport Rick from Westville to Delphi. I agree that this is kind of stupid that they have that excuse. I'm saying like Carroll County and Liggett saying, oh, we can't transfer him. It's like the Department of Corrections has like all these guards around Rick when he goes to court. Like you can't like have the same thing from Cass County, please. The court's refusal to intervene is prejudicial to Rick and in violation of this rule and violates Rick's Sixth Amendment right to present a defense and runs afoul of his due process rights under the state and federal constitutions. And Gull's failure to take common sense measures to move Rick out of Westville, especially after it was proven that he was guarded by practicing paganists/Odinists. Yay, they referenced it right. When evidence and allegations exist that Odinists were involved in the murders, provides a rational inference of bias against Allen. I disagree with that those two guards are involved in the murders, and I think those accusations by Walden and Rosie about those two guards are, I really feel like they crossed the line with that. 17. Gull has treated the prosecution more favorably than defense counsel. In the Franks memo, the defense provided evidence exposing false and/or contradictory testimony by law enforcement and the withholding of exculpatory evidence by the prosecution. If you remember Tom's definition of exculpatory and inculpatory, exculpatory means it excuses the defendant. So exculpatory evidence is good for Rick. Inculpatory evidence means you in danger, girl. You're going to be in jail for the rest of your life. The state was continuing to provide large quantities of discovery into October of 2023, nearly 10 months after Baldwin and Rosie started, causing Baldwin and Rosie to seek a discovery deadline of November 1st, which McClelland said he met that November 1st deadline. In my Franks memo, as I've said, I don't expect anybody to have watched all that, but I did repeatedly criticize McClelland and the investigative team of taking so long to turn over this evidence, which to me signaled that they were so disorganized during the 5.5 years of investigating it. And I understand that there were so many different officers and so many different tips, like 80,000 tips. I understand that, but it just seems like they were not organized at all, including like Doolin, the conservation officer, saying, oh, I lost this recording, this audio recording of Rick from 2017. Well, why was part of the procedure not to automatically, with that tip, within the next day or so, to give that audio recording back in February 2017? Hello? All right, where am I here? The state was continuing to, I already said that. Let me just repeat this again. The state was continuing to provide large quantities of discovery into October 2023, nearly 10 months after Baldwin and Rosie started, causing Baldwin and Rosie to seek the discovery deadline of November 1st. Despite the state's intentional behavior, so McClelland, including the non-disclosure of exculpatory evidence, Gull focused her ire on Baldwin and Rosie for gross negligence. McClelland was in possession of a highly exculpatory document by Officer Todd Clicks, in which Click alerted McClelland. He was concerned that McClelland had not been informed about Click's involvement in investigating a group of men whom Click believed were involved in the murder. So this is the guy, Todd Click. I think he worked in this area called Rushville, which, if you paid any attention to the Frank's memo, they basically said there were guys from the Delphi area and I guess Logansport, I think, and Rushville who were Odinists who did the sacrificial ritualistic killing of Abby and Libby. Although Click, I guess, said he did not believe the ritualistic sacrifice part of it, but he felt like those 5 or 6 guys were involved in the murders. My concern is, did these 3 guys have access to all the evidence and alibis that the Unified Command did? So basically, Click hired a lawyer because he read the PCA and felt like there was not enough evidence against Rick to arrest him compared to all the evidence that Click and these 2 other guys, Ferenczi and Murphy, had collected. And they wrote up like an 85-page report, which is known as the Click report or the Odin report. I don't know. Let's see. Evidence that third parties involved in Odinism had murdered the girls. McClelland held on to that highly exculpatory document, that letter that Click wrote to him, for nearly 4 months until September 2023, which prevented the defense from questioning investigators about the exculpatory information during defense depositions in early August. So Baldwin and Rosie interviewed Holman, Liggett, and Lesenby in August. And so their contention here is saying, we didn't even know about the Odinists. If we did, we would have asked whatever, Lesenby, Liggett, and Holman about this stuff. And so this failure will require additional depositions and prolong the discovery process, which I agree with that. But I would like to hear from McClelland why it took 4 months to hand over that letter. I don't know what the answer is. From what I saw, they have until 10 days before the trial to hand over evidence, but still, if you have this evidence for 4 months, you should be handing it over. In my Frank's memo video, I said, why were they taking over 10 months to hand over videos, which they still have not handed over videos, the prosecution to the defense, that were taken in 2017? It's like, what's going on? That's not acceptable. Gull has never chastised McClelland that his behavior appears intentional or grossly intentional, or at least grossly negligent, which I somewhat agree with that point. The fact that Gull has solely focused her ire on her perceived belief that Baldwin and Rosie are grossly negligent and incompetent, while not addressing the prosecution's provable discovery issues, provides a rational inference of bias or prejudice against Rick and his defense team. I do agree with that. It does look that way. At least in that one slide and that one contention about discovery and withholding stuff. 18, Gull engaged in unacceptable extrajudicial activities. This one, I think this is so ridiculous that the defense is even bringing this up. July 9th, 2023. The defense is apparently stalking the Facebooks of Judge Gull's family members. So July of last summer, someone who is believed to be Gull's then daughter-in-law published an entry on her own Facebook page stating the following. Whoops. What an honor. Quote, what an honor. So this is Gull's daughter-in-law. I don't know what it means, then daughter-in-law. She divorced her son or something. Quote, what an honor it was for the girls to play in the Abby and Libby Memorial Tournament. So a lot of you guys know there's a softball field that was built in honor of Abby and Libby. What a great honor it was that Abby and Libby's grandparents presented our girls with their championship finalist rings, end quote. So that was, I guess, Gull's daughter-in-law posted that on Facebook. The defense proceeds to say, in spite of being the presiding judge in this case at the time this message was posted, Gull made a choice to publicly comment on the post of her daughter-in-law with a simple congratulations. How dare she? While this post may appear to be an innocuous comment, to Rick's counsel, it raises fair questions about whether or not a rational inference of bias or prejudice exists. I say, you're crazy. As the presumable relatives of Gull, who are mentioned in this post, will likely see Gull from time to time, communicate with Gull, and have opinions concerning the murders of Abby and Libby. Who the hell? I'm busy, sorry. If you knew who was calling me, you'd be like, oh my gosh. Anyway, as it wasn't Kagan. As the presumable relatives of Gull, I thought you said you were watching this, lady. Anyway, as the presumable relatives of Gull, who are mentioned in this post, will likely see Gull from time to time, communicate with Gull, and have opinions concerning the murders of Abby and Libby, and Gull must know that her relatives may have been emotionally impacted by their involvement in the softball tournament, especially from interacting with Abby and Libby's grandparents. Yet knowing all of this and knowing that Gull will be challenged with resolving evidentiary and procedural disputes in this case, she chose to comment on the post, like saying congratulations to her possible granddaughters or something. I don't think that's crossing any lines. This is the last slide for this number. In 2013, the American Bar Association issued, quote, judges' use of electronic social networking media, where judges were cautioned to be conscious of the way their online relationships will appear to others. Publicly commenting on a post concerning a softball tournament that honored the victims in this case provides evidence of a rational inference of bias. I guess that's up for everybody else to decide. 19, a few more. Timing of judicial bias, prejudice, and lack of impartiality. This code requires that good cause be shown when any movement for a change of judge cannot meet the 30-day timing requirement referenced in subsection 1 of the rule. Rick asserts that the first time Gull's bias was cemented in the minds of the defense occurred during a phone call between McClelland, Baldwin and Rosie, and Gull on October 10th, 2023. When McClelland made a reference to disqualification. With very little hesitation, Gull suggested she was leaning toward disqualification and ordered them to appear October 19th when she staged a premeditated severing of Baldwin and Rosie, leading to contentious and very public litigation. Yeah, we've heard. Gull's actions predating October 10th, 2023 are now viewed as evidence of a continued pattern of bias, such as Gull's failure to pay Baldwin and Rosie in a timely fashion and continued failure to protect Rick. Baldwin and Rosie could not file their motion for change of judge until after the Indiana Supreme Court reinstated them. Next, sorry, I was replying to a text. Okay, so this is the last page. It says, it is from this set of circumstances that Richard Allen asserts his claim in support of his motion for change of judge from Judge Francis C. Gull, signed Rick. So they spelled Francis wrong, just to, I guess, piss her off. Francis, it's ES, but okay. Is anybody still here? Whew. Now to your comments. I'm an hour and 10 minutes behind, let's say. Steffa says they could send Rick to the state hospital for the criminally insane and get him stabilized, then send him back to jail. It's not rocket science. Well, apparently he's been evaluated by various mental health professionals, and they say he did not need involuntary medication or to be transferred to, like you said, one of these state hospitals. Hi, Digital. I'm sure most of these people are gone. So who said he was talking about self-harm before he had attorneys and threw him in prison under protective custody? It was the reason that they transferred him out of Carroll County was not because, actually, I don't know if it was because of self-harm. It was more harm by other inmates. Carroll County Jail is very small, and they said that they have 5 full-time jail guards, and they just can't, I guess, control a 5'4" man. I don't know. Hi, Metal Mama Michelle. And his attorneys put a request for him to be moved. They move him, still not good enough. It's never going to be. Again, people are easy to manipulate and fall for it. Well, I agree that attorneys should not have to drive so far. I can remove this banner here. Kevin says, why did Liggett say he didn't know where the Purdue professor was when he did? Too many strikes against Liggett. I think that was Holman who said that. And then the following day, so that was September 18th, the Franks memo was released and the world bowed down. And then the next day on the 19th, Holman interviewed the Purdue professor. I think it's BS that he lied and maybe said that he did not know the name of the professor, and then the next day he interviews him. On the other hand, I can understand how he would want to see what the defense put in the Franks memo before he talked to this professor. But, I mean, why not just tell the defense this is the guy's name so they can contact him themselves? This Mel said to Stefa, but then he'd be found incompetent if he's whatever, has mental issues, which would nullify the speedy hearing, which is probably what the defense is after. Yeah, I think some people have said it might take up to 6 months for somebody who goes into a mental health institution, like an inmate, for them to, I guess, be found mentally incompetent to go back to, I guess, a jail or whatever, prison. Humanimal says they need to make arrangements for remand inmates if they have to wait trial in prison for various reasons. He has a right to be able to meet with his counsel. I agree, and not through like this hole in a door. Prisons are set up for this. Prisons aren't set up for this at all. It seems that way, but don't a lot of people who are convicted file appeals and then still have to meet with their attorney? So why is there not a dedicated room in a huge prison for attorneys to meet their clients? Please stand by. Somebody watched my live chat, but they had to eat. They had better things to do. USA Libertarian, most likely because Liggett wanted to get the okay from McClellan before giving the defense anything. I don't know. I don't know if McClellan was waiting for like all of the Odinist related discovery evidence to send at the same time to the defense. Some people might think that's ridiculous, but I don't know how this process works of collecting evidence, giving it to a prosecutor, and then the prosecutor handing it over to the defense. Luna Ray says something that a lot of people say, seems to me this state doesn't want this case to ever go to trial. I don't know. Why did McClellan file 4 more charges? Peter says, isn't that a funny statement? Quote, I know Rick is in prison, but exclamation, quote, exclamation, oh, sorry, question mark. He hasn't even been convicted and he's sitting in prison. Well, I have yet to really hear anybody give a good solution for the most notorious person charged in Indiana right now in the Department of Corrections. Where do you think Rick should go? Which county jail? What is his access to other prisoners? I don't know. Like, what do you think? And if a county jail only has a mental health professional come in once a week, do you think that's good enough for Rick if he's having mental issues? I just don't see or know what the perfect solution is. I understand what you're saying and other people are saying, but it's a pretty complicated thing, in my opinion. This Mel says Lesenby was the one who lied about not knowing where the Purdue professor was. I thought it was Liggett. Matt says the prosecution is very whiny. They don't have a case. Why did they just file 4 more charges, saying not that Rick is only bridge guy, but also the murderer? I don't know. I don't think any of us should be saying we're 100% certain of Rick's innocence or guilt at this point. We don't know everything that the prosecution has or what the defense is going to say too. You call a meal slot 6 feet from the door accommodations? It was a temporary meeting, which as I said, I don't know why there's not a dedicated room for this kind of stuff. They had them meet in a kitchen. That was where that photo I showed. Support with Steffa has some experience, I guess. I'm not saying that she was in a mental institution, but I think she's a practitioner or something like that. Sorry. He does not have to be incompetent to go to the state hospital. They have patients come and stabilize them. Hi, CJK. A retired law enforcement said there are rooms in prisons where attorneys can meet with their client. True. I don't know. I abide by the laws. Yeah, me too. I need to go to prison to get some experience for my live chats. Support Steffa says, my last YouTube video interview 2 state hospitals for the criminally insane, and it's amazing what patients they take. All right, check out Support with Steffa if you want to see an interview with state hospitals. Hi, Miss Persevere. Most of this is standard procedure. However, they state that face-to-face visits are not allowed, and I know that isn't true here. Where are you? Indiana? Lady Monet says the Department of Corrections has facilities much closer to his lawyers. Mary Rigsby, yeah, please be respectful. If somebody's not being respectful, just you can ban them if you're a moderator, and if you're not a moderator, you can just click their name and ignore them. Hi, C4P. Give Ricky a chance. I don't know what the hell's going on. If people are being rude, just like don't give a warning, just ban them. Devoted to Mariah says, the only thing I think is a bit excessive is the chains on him with 6 guards when he goes to court. I totally agree. He's 5'4". They have shackles around his ankles. They have something around his waist, and he's handcuffed, and it is way too excessive. Ryan, hi Ryan. Did anyone ever find out why he was transferred from Westville to Wabash? There's never been any like official explanation why they randomly did it. I know that they're building a new Wabash prison for $1.2 billion, but they just recently like had a ceremony to start it. So it's not like I don't think they're doing it because it's overcrowding at Westville, but I'm not sure. Bees said, does anyone realize other attorneys have to travel that far too? They aren't the only attorneys in the world. Reality check time. I don't know if I'd be that extreme as you, but I just don't think it's right for 3.5 hours from his attorneys. At this point, have a hearing, tell Rick what the conditions would be at Cass County, which I don't think it's really part of the procedure to say, okay, inmate, what do you want? We'll put you wherever you want to go. Kevin says Brian Koberger walks into court like he just came from the country club. Meanwhile, Rick is in an orange straitjacket and shackles. I agree. It's kind of ridiculous. But has Rick been given the opportunity to change into a suit? I don't know. And isn't Koberger? Koberger is not going from outside to inside. Isn't he like hanging out in the basement of the jail, which has the courthouse there too? Metal Mama Michelle. If it's shown during trial that the state has compelling evidence we are not privy to and is damning to Rick, will those making Rick and the defense, the victims, admit they were wrong? Curious. I guess, Michelle, you're going to have to wait and find out if there is more evidence and if it looks like Rick is guilty and how those people will maybe say, okay, I was wrong. To me, it's not like a game of like, and I'm not saying you were saying it is, but it's not like, oh, I was right and you were wrong. I just want the truth to be revealed. And if Rick truly was the bridge guy and or the killer, for him to be held responsible and accountable. Hi, Kelt, but he's already not leaving his cell at the other places. So I don't know. Send him to Cass County. Sorry, I'm just looking for comments that we haven't discussed. I'm an hour and 10 minutes behind. How long? I've been 2 hours and 1 minute. I usually go like 2 hours and 59 minutes, which I'll probably do today. But as it said, like, I mean, right now they implemented a new feature for video conferencing between inmates and their attorneys, which, as I said before, I'm sure some people would freak out saying, oh, well, McClelland's going to get access to those videotapes, which he should not. Thank you, Michelle. I agree. I just want the truth. Thank you for your generosity. I appreciate it. And thank you for sharing your opinions. Sorry, I'm just looking through some of these comments here. Lady Monet says small county jails have small conference rooms to meet with lawyers. Yeah, I mean, I think just because he's in a prison, they should give him access to his attorneys the same way somebody in a county jail would have access. So if that means that people in county jail don't have to wear handcuffs in this attorney-client room, then Rick should not have to be in shackles and separated between a door. I mean, it's just, he is innocent until proven guilty. Let me skip over a bunch of things here. Hi, She Elf Johnson. Thank you. I appreciate it. Thank you for copying, Michelle. Hi, Picture Chick, too. Are Rick's visitor logs public information? I don't know, because I know that Kagan's were. Kagan Klein, his visitors, I think, were public information, I think, with a request. I think in the Alec Murdaugh trial where he killed his wife and his son, didn't people request his phone calls before he was even convicted while he was in jail? I know that one reporter requested the transcript of his phone calls, and I believe it shows on this website that it was processed, but It was somebody from Court TV, and obviously Court TV has never shared them, so I assume that it was not allowed to be shared. Humanimal, and people have to make the decision. I wonder what Rick himself would say about it. Does he want to be held in a county jail? I say let's hear from Rick, or at least the judge should hear what he wants. Have a hearing. Hi, Katsu. I think it's also got an element of keeping him safe to it. In a prison, they can keep him away from other inmates that might try to retaliate against his alleged crime. Well, somebody made a good point that in county jail, if people are there awaiting a trial for like drunk driving, are they really going to murder Rick and add a murder charge to and like ruin the rest of their lives just to beat up or kill Rick? I doubt it. But is it worth risking that? Rick is only 5'4". Do you want him to be out in the open with people who have like anger management issues? This Mel. Appellate attorneys don't really need the client to review evidence and plan trial strategy. It's all about the record versus trial counsel is there to ensure that his rights are not being violated in custody. All right, thank you. Hi, Candy. Say hi to everybody in New Zealand. Ryan says, God, just get the trial done. And if he's guilty, then put him away and give him no consideration. For the record, I think it's likely he is guilty. There was no doubt based on your first sentence. I don't know. At this point, I'm just like, either he's guilty or he's innocent. The state either has evidence to prove it or not. The defense is going to do what they're going to do. Can we just like, for the sake of Abby and Libby and their families, and for Rick, if he's innocent, he should not have to wait another, whatever, 9 months for the trial and be in solitary confinement. And I'm sure Rick's wife, mom, and daughter want to hear the evidence and see, is Rick truly a double child murderer? Was he being honest when he told them he was? Or was he suffering some kind of mental health break, which again goes back to he's not going to get mental health help in a county jail. Instamat says devoted to Mariah is a Tom sock account. I swear to God, that's not me. USA Libertarian says I prefer Zoom meetings. Bees9 says all travel expenses are paid for by tax dollars. It's called travel expenses and they can stay in a hotel. In LA, most people commute that long a day. I don't know, but like a 10-hour day just to like talk to Rick. I don't know. It seems too excessive to me. But I don't know. I'd be interested to know, have Baldwin and Rosie been utilizing this video service? I don't know. Necessary evil. I see Indiana people in Florida all the time, and none know of Delphi equals necessary evil. Talks to people in Florida, and they say, I'm from Indiana, and necessary evil says, do you know about Delphi? What can you tell me? Picture Chick. Is there a trial date yet? October 15th, 2024. That was done after Librato and Scremin were appointed. And now that guess who's back in the mother effing house, Baldwin and Rosie are back. So when are they going to file this 70-day request for a speedy trial? Ryan makes a good point. If he dies in prison before trial, there is no justice for Abby and Libby. The case dies. I agree. I mean, Rick needs to be healthy physically and mentally, and just convicting Rick falsely solves absolutely nothing. However, some people are like, well, the state is trying to kill Rick. Well, they've done a horrible job of it. Like, it's been, what, 14 months since he's been in jail? And he's still alive? I don't know. I think people exaggerate a little bit. Peter is in Australia. Thank you for everybody around the world for joining and sharing your thoughts. Oh, Luna dissed me before, but now she's saying, I'm sure it's written better, much better than whatever McClelland did. McClelland did make some errors, so I call out the defense and McClelland also. Let me skip over some more. Sorry, I'm just looking for comments that we have not really talked about yet. Yeah, this is an interesting, I haven't read all of it yet, but Kevin, if Rick had an accomplice or knew the girls or been researching murder, there would have been history of that on some of his electronic devices. That would have been uncovered early. Yeah, so there are 7 things in the Frank's memo that the defense said were good for Rick. One of them was that no social media connected Rick to Abby and Libby. Also, like no DNA from Rick was found at the scene. But as I briefly pointed out before, in the Frank's memo, the defense conveniently left out, the whole thing of the Frank's memo was saying that Liggett intentionally left out incriminating things against Rick, or no, that exculpatory evidence for Rick. But in the Frank's memo, the defense did the exact same thing. Not once did they bring up the 127 video at Hoosier Harbor Store, which apparently shows Rick's car, or a car matching his, headed towards CPS when Rick said he left at 1:30. Not once did they reference the 4 juveniles who walked within a few feet of Bridge Guy as he entered around 1:20 or 1:30. They said he was in his 40s to 50s, and essentially he kind of looked like Rick. The defense never once mentioned those girls' descriptions. They never once mentioned the 210 and 228 car descriptions of the car CPS. They only referenced that the witness 4 said it looked like it was from the 60s. Ryan says, sadly, all this mess has probably already guaranteed a mistrial, appeal, overturned conviction. Yeah, I'm not expecting a resolution at the trial, if I'm being honest. Like, okay, what? Rick is guilty. He'll never appeal. Everybody was satisfied that the evidence presented at the trial was convincing that Rick was involved in the killer. And these latest charges, are they inferring that some other people were involved in the killings? It's now been what, like 14 months after they started looking into Rick. They haven't arrested anybody else. C for P says, give Ricky a mattress. Well, part of that supposed untruths in that Rosie wrote in the motion to modify safekeeping order, they said Rick is sleeping on a pad on the floor, insinuating that he didn't have a bed, which the warden said, yes, he does have a bed. Send him some commissary money and maybe he can buy a bed. DNA King says there's really no question that Gull should recuse as presiding judge. I don't know. I said I don't need her to be the judge, and at this point, it's just going back and forth. I don't know. It's just such a delay that I don't know. It just doesn't seem necessary. Foster Dogs of Memphis. That's the first time I've seen that screen name. Gull has so much more info about Rick than we will ever know. You are correct. Rick confessed. 2 exclamation points. His attorneys ran to save face. Defense did what they had to do to divert attention from Rick's, you probably said, confessions. I don't know that I'd say that you're wrong. If your client apparently calls his wife and confesses, then what is your reaction? Probably not a good day for Baldwin and Rosie on April 3rd. Oh. Humanimal, what's the story with being named, i.e. in the Frank's memo, can the Odinists sue? No, they cannot. Anything that a defense attorney files in a public motion, apparently it's not considered slander or anything like that. I know that they said some of these Odinists who were named, which obviously those names came from law enforcement, they were very upset and said there were a lot of negative repercussions for their job and their families and stuff like that when it came out on September 18th. As far as I know, none of them have sued Baldwin and Rosie up to this point. DNA King, if Gull has more info than the public has, she definitely needs to recuse. She should only have the info in the court files and the testimony adduced in open court. Well, I think she meant that the previous poster meant she has access to certain court filings, like the exhibits included in the Frank's memo, that those are not publicly available. Moderators, if somebody says anything, just don't give them a second chance. It's just not accepted here. Thank you. Peter says, didn't Gull just get a promotion recently? Isn't she now, quote unquote, in charge of the judges or something like that? Even if she goes, she's still in a conflict. I didn't know exactly what her new role is, but I think somebody said it might be similar to being the president of your homeowners association or something. Like it's no like big deal or anything. And the judges may rotate in that title, so it's not like a huge promotion. Whatever. Digital says that DNA King is right. Some people just don't get it. Gull is a referee. She shouldn't know the plays. Shaking my head. Well, as I said, the defense wanted her to read 126 exhibits and watch 7 hours of depositions of law enforcement. So she does have access to some of this stuff. Foster Dogs of Memphis. I don't think it matters who the judge ends up being. Evidence will give the jury the answers they need. I personally believe the evidence is overwhelming. That's why Rick freaked out and confessed for a plea. Well, as far as we know, there's not been any plea deal done. And it's now 14 months later, and Rick has not publicly changed his not guilty plea. Luna says, no, a judge does not have access to all of the evidence. Heck, she didn't even read the Frank's motion, probably ever. We don't know that, Luna. But I really do want to know, DNA King, do you know, have you ever dealt with a Frank's memorandum? How many pages have you seen, like the most? Is 136 a bit excessive with 126 exhibits? And they didn't even get to the violations of the Frank's memo until page 105. I had to read every word of it, so if I did, Judge Gull should have to also. Maybe she watched my video on 2 times speed. I'm kidding, I don't think that. USA Libertarian, the judge is not there to judge Rick. She's there to make sure the jury sees the appropriate evidence. Well, she's saying that she is also responsible for making sure that Rick has proper attorneys, and she felt like Walden and Rosie were not up to it. That's why she removed them. Digital offers some more explanation about Judge's Gull's quote unquote promotion. It's a paper pushing pain in the butt. The judges rotated and it was her turn. So it's not like a huge promotion. Metal Mama Michelle says, please submit your complaints to the Injustice, Indiana Commission, whatever. There you go. Pause it if you want. Hi, Caricature Contest. I'm beginning to hate this case because Abby and Libby are getting lost. I hope they glow them up during the trial. Yeah, I mean, it's just insane to me that the judge got an attorney, the attorneys got an attorney, and they're still just fighting back and forth. I'm over an hour and a half behind. Matt says people forget that Rosie was not part of either either the leak or the email accidentally being forwarded. She has zero reason to remove him. I agree with the first sentence, but I mean, you wrote it an hour and a half ago before maybe you saw the possible lies that Rosie told. I'm sure some people feel like they were not lies, but I don't know. Oh my God. Devoted to Mariah, that's a no-no. Sleuth Intuition would not reply to you with that answer. Kevin says, after Baldwin withdrew, he shouted to the press, quote, you guys better do your jobs. I think he said, time to start being journalists or something like that. Was he referring to police corruption in Delphi that the defense team has uncovered and will bring forth at trial? I mean, I understand that there's like shady S going down in the city and the county, but I've always only cared about identifying Bridge Guy and holding him accountable. This guy on the bridge, whether it's Rick or somebody else, like Tony Liggett and Holman and McClelland had nothing to do with the motivation for this guy walking up to Abby and Libby, pulling out a gun and saying, go down the hill. So I get that like corruption might prevent like the right person being found and tried, but I mean, this guy had his own motive. So hopefully at the trial, there's going to be enough evidence to show, is the state right saying that Rick was Bridge Guy and Rick was the murderer? I don't know. Danielle says, it says enough about Gull that she won't recuse herself when there's even the appearance of impropriety and increased chance of appeals based on perceived basis. I don't know, maybe after this latest filing today, she will change her mind, or maybe not. I don't know. How long is this going to go back and forth? I don't know. Hopefully not for too long. But at what point are Walden and Rosie going to be satisfied? And at what point is Gull going to be satisfied with them? I don't know. B's 9. They can send their intern again if they don't feel like driving to check on Ricky. Plus, there are cameras too if anything questionable happens. This is part of their strategy to, I don't know, just put Rick in Cass County and stop arguing about it. Luna says anybody who wants justice for Abby and Libby should be calling for Gull's recusal. If she oversees this case, if Rick is found guilty, that ruling will be overturned. Well, if Rick is found guilty with Bolton and Rosie, is he going to say, even the judge said they were incompetent? I mean, it goes both ways, I think. Should they just go on Judge Judy? Oh my God, imagine Judge Judy being the judge. Would Judge Judy like Bolden and Rosie or McClelland? Kelt says the Supreme Court found Gull did not follow correct procedure. That's true. Her own lawyer called the lawyers more than competent. We have about 30 more minutes in this live chat for anybody who's wondering. But thank you for joining and sharing your thoughts. Ryan says, see what's happening. People are hardly talking about the actual case anymore. It's all lost in the back and forth and finger pointing between the judge and defense and prosecution, which some people say is a defense strategy. Hi, Providence. I haven't seen you in a long time. Hi, SP74. I have seen you recently. ISC, Indiana Supreme Court, thank you for not writing SCOIN, also agreed unanimously not to remove Gull and suggested she hold the hearing to address the defense's violations. Yeah, just a reminder. So this hearing, I guess, was January 18th. The same day, Indiana Supreme Court issued their ruling, but it was like a one-pager. So the Indiana Supreme Court is going to issue a longer written opinion about, I guess, their decision to reinstate Bolden and Rosie and to not remove Judge Gull. The third issue of the 70-day speedy trial, Bolden and Rosie can file that at any point. So they've been saying, we want the speedy trial in 70 days. So it's been over a week since they've been reinstated. So where is this 70-day request? Hi, Crispy Treat. I'm still over an hour. Sorry, everybody who I'm just skipping over here. Let's see what else you guys are talking about. USA Libertarian, just wait until they start arguing over the confessions. Well, I'm hoping that Nick McClelland in some kind of filing is going to include a direct quote. Or why not release the entire transcript of it? Is he waiting for the trial for some kind of, like, I don't want to quote Oprah and say like an aha moment, but anybody who's been following this case for the past few months, everybody has their opinions about this April 3rd call. People who think Rick is innocent say, well, we don't know exactly what he said. People who think Rick is guilty say he admitted he was guilty. So he said something that wasn't good. Sinbad Sailor, go to the court website and check out the new contempt of court filing by McClelland. I started out this live chat with that, I think, didn't I? I don't know. Danielle says, denying Rick and his counsel access to the transcript of the October 19th in-chambers proceedings. Who can question her need to recuse herself? Yeah, I agree that that was just unacceptable. And also the defense saying they still have not gotten the transcript from the June 15th hearing. That's unacceptable. As Ryan says, it's so frustrating. I don't know what you were talking about, but okay. Yeah, we haven't heard from Doug Carter lately. Can somebody check on him? We haven't gotten a good haiku or poem from Doug recently. Kevin says, uh-oh, hope Doug isn't watching. I think you mean DC, unless you're talking about Destiny's Child and you're not a big Beyonce fan. Doug Carter annoys me with his ambiguous messages. The shack references were from religious overtones at the crime scene. R.I. also said this. Odinism, paganism, religious beliefs with Robert Ives also said this. Odinism, paganism, religious beliefs with sacrificial practices. I don't know. I don't know what's next in this case. No, B's 9, the full written opinion by the Indiana Supreme Court. I watched one other hearing, and it took about 10 days for the written report to come out. Let's see. SP 74, Judge Gull is a special judge assigned to this case since they could not find like a jury in Carroll County. So they went about, I think, an hour and a half away is Allen County, which is where Gull is a judge. And so she was assigned to this case. I'm almost certain she was the one who assigned Baldwin and Rosie from the list of public defenders. So I don't know. As I said before, there are several former Indiana Supreme Court justices who also now work as special judges. So why not just have one of those people replace Gull? I'm just really shocked that so many people in government in Indiana do not follow basic procedures. Malibu, hello. How's Barbie? If we hear from Rick, we will hear his voice, quote or question mark, down the hill. Is that a reason why Rick has been afraid to speak out? I don't know what's going on in the chat an hour ago, but yes, really no need to attack anybody. I don't know who I haven't seen anything, so hopefully those people were banned. Hi, Bossy. Bossy says, yeah, let Rick speak up. I want to hear what he has to say about his conditions and where he wants to spend the next 8 months until his trial. B's 9 says, I guess the defense thinks another judge will give them a hearing on Franks, not because they think they will win, but because they want to put on a show. Devoted to Mariah says, Rick has spoken in court. It must have been one of those, one of the ones that were not televised. And one of the YouTubers who was there said it does sound like Bridge Guy. Well, we know that they, hopefully, police had to have video and audio taped Rick's October 13th and October 26th, 2022 police interviews. They have to play this audio recording from April 3rd. McClelland has to, at the same time, play Go Down the Hill. Unless it does not sound like Rick, then is he not going to do that? Hi, Angel Ray. I've had a recurring, I think you messed up here. I don't know what you meant to say. There's a recording of Rick's voice since his arrest. I got it from Kathy Allen's Facebook. It's hard to tell if it's him or not. I agree. So they have that one where they're going down the ski lift. And there's also one, I think, in a bar. Also, some people called Rick's cell phone where he says, Rick. And some people think it sounds like guys. I don't know. Some people think it does. Some people think it does not. I'm not highlighting that one. SP 74, judges don't have to grant a hearing on every single motion. Well, I don't think there was enough evidence to grant a Franks hearing. Without the lies, I think there's still enough evidence to grant a search warrant of Rick's house. Digital says Gull isn't supposed to be nice. She's supposed to follow the law, but I don't think she did follow the law in some of those things pointed out by the defense. I'm still over an hour behind. Oh my God. All right, I'm skipping over a half hour. 23 more minutes. Yeah, I agree with this. SP 74. Rick probably isn't aware of half of what his counsel has done. I want to know, how much is Rick contributing to his defense? How much of this evidence is he reading? I'm not going to make a joke about him eating supposed evidence, but I just want to know, like, if you were this person falsely accused of double murder in your small town, and you wondered for 5.5 years who was this guy, and you finally get tons of papers about what the prosecution found and like what this investigation showed, and you're in your cell 23 hours a day, 5 days a week, and 24 hours a day, 2 days a week. Are you doing crossword puzzles, or are you reading this evidence and writing down, oh, the prosecution says I'm guilty because of this? Well, no, you're wrong. Here, and is he taking notes? Like, is he reading a lot of this evidence? Is the answer no, because he knows the answers and he is guilty? Or is the answer yes, that he has been very active in assisting with his case? I don't know that we're going to get that answer in the truth, but I don't know. I mean, I do think that McClelland, if he has access to video of Rick's cell 24 hours a day, I'm not sure that he's like watching it every day. I'm sure some people think there's like a software where McClelland has it on his desk all day long. Is he going to show that when Rick gets these big pieces of paper, is he reading it, or does it just sit in his desk and he never like reads this evidence, trying to help his own defense? I don't know. It would seem suspicious to me if he's not. Devoted tomorrow. I see what you're doing. Does Rick want to be taken out of jail so he forever remains innocent and gives his mom wife some saving grace? Like, Rick has to be aware he's high profile. It's odd he wants less protection. Maybe against all odds, he'll like beat these charges. Only Devoted to Mariah. I know what we're talking about here. Anyway. Hi, Tiff. A face tattoo guard. I've almost got bingo. Oh my gosh. Like, he's really not going to get a tattoo because Walden and Rosie said he's involved in the murders somehow and harassing Rick. Hi, Matlock. The court process was being dragged off the rails by defense antics. It was correct to address the conduct while lawyers were court appointed. Try to resist the defense writing narrative otherwise. I don't know. This needs to be highlighted. Remy Ratatouille. I love how much Tom hates doing these live streams, but he still does them for us. Seriously, I do them because people say they don't follow every update of the case, so I try to give updates. And some people say they hate everybody else who hosts live chats and they don't like Reddit and stuff. So I try to provide a forum for people to get updates and hopefully talk politely to other people about their opinions. Luna is a big supporter of Rick, and that's fine. Most likely, Rick is losing his mind due to horrible, inhumane conditions. Why are you laughing at that then? My issue with that, Luna, Ray, are you related to Sugar, Ray? Sorry, I just improvised these stupid jokes. Why did the defense say in their April 5th, whatever, the motion to modify safekeeping order, they said for the first 5 months that Rick was at Westville, he did have deteriorating physical conditions, but they said mentally he was fine in solitary confinement at Westville for the first 5 months. They said they saw him March 24th and he was fine. It wasn't until April 3rd, which, as I've said previously, I'm really just suspicious that April 3rd, the defense intern and investigator go meet Rick at Westville. It's not been proven yet if Rick made the phone call before or after that meeting with the defense team. If I had to assume, it seems like they gave him some kind of evidence because the warden said after Rick was given legal paperwork, he started showing odd behavior. So what kind of evidence was Rick given on April 3rd that totally changed his demeanor from the past 5 months? I don't know. It's just suspicious to me, that whole timing of that. All right, what are we doing here? I'm still an hour behind. Hopefully you guys are like getting something out of other people's comments. All right, I was skipping. Hi, Big Fish, Small Pond. Hi, Anne. Do we have any idea when the trial might be? Yeah, October 15th, but hopefully Baldwin and Rosie will file this 70-day request for a speedy trial tomorrow. Hi, Georgia. They said they could keep him safe in Cass County, but that's because he would be in his jail cell all day long and never get recreation time if he's saying that he's having suicidal thoughts. But if you're innocent and you know you're going to be proven innocent in 70 days, why are you saying you're going to kill yourself? It's just, I don't know, it seems suspicious to me. And wait till you see my next Delphi video within the next week. Hi, Ellie Joe, up late in London. I don't know what you're talking about. Hi, Love to Hunt. Maybe Rick's mental health includes volatile outbursts like slamming and breaking of things like his tablet and things in his cell. So to protect everyone, he needs the vest and chains. Yeah, well, I think it was, I don't know if it was in the Frank's memo, but there were 2 references by the defense to Rick being tased or tried to be tased by the Odinite guards at Westville, which I'm not laughing at him being tased, but at the Odinite description. But one of these 2 references, these incidences, were they had to tase him apparently because if you saw before, like there's like a slot in the door for food and stuff. And apparently the rule at Westville or in any prison might be a prisoner or an inmate, Rick isn't a prisoner. He's not supposed to be putting his hands outside this slot in the door. But apparently he was, and not listening to the guard saying, put your hands back in there. And that is when he stopped. He wasn't listening to them and pulling his hands in. So the guards tried to tase him, which I do think that's excessive and not necessary. If a 5'4" guy is behind a prison door, like you don't have to tase him for that. I don't know what the whatever punishment is, but still. On the other hand, it's like, why can't Rick follow simple instructions to keep his hands inside the door? And where is this video? Like, I don't know. Let's see. We have 13 more minutes, and then I'm out of my misery. So when's my next live chat? Hopefully never. I don't know. I'll probably do a live chat. So I have this video that I've been working on for the past 2 weeks that people won't like. I'll probably do a live chat to hear people complain about me. What could it be about? Well, I'll tell you a quote. I'm still working on the script, if you want to call it that, and pictures, but as I was doing it, I thought, Shakira is a singer who has like a wobbly voice. She's no Mariah. She has a song called Hips Don't Lie. And as I was like looking into this thing, which I'm so surprised that nobody else has really looked into, I guess other YouTubers are busy complaining about other YouTubers while I'm in my recliner doing spreadsheets. So while I was doing this, I thought, like Shakira's hips, the numbers don't lie. So hopefully that video will be under 1 hour. Devoted to Mariah, I'm shocked nobody messed with Ron Logan in jail. Maybe he's huge and has scary eyes. I don't know. Some people say he has something in common with a horse. I don't know. Next comment. Hi, Fair Maiden Wins. This is Naples, Italy. That's the volcano that erupted and people got buried in Pompeii, which I went to Pompeii and I wanted to steal some stuff. I'll have to delete that in the replay. I did not steal anything from Italy. Anne says, the thing is, I don't think Rick has formally invoked his right to a speedy trial. His lawyers keep alluding to that in their various filed screeds, but I never heard the word screeds, but they've never actually made that motion, as far as I know. They had Rick sign it in August. They had not filed it as of October. I think they were waiting for the discovery deadline, November 1st. And then their plan was to file it to ensure the January 8th of this year, like 2 or 3 weeks ago, the start of the trial. I don't know. Some people have said, well, the defense job is to just keep delaying stuff and filing as many things as possible to throw out the evidence and the arrest warrant. So were they truly going to say, okay, we've tried everything, I guess we have to go to the trial? And people say the prosecution doesn't want to go to trial, but does the defense not want to go to trial? Hi, KT. 2 is the answer. That's between you and me. Another YouTuber, a lawyer, revealed recently there was nothing on any devices in Rick's home or possession that showed communication with Abby or Libby or any kind of nefarious content. Yeah, I've referenced this list of 7 items in the Frank's memo, which were good for Rick, which I agree, those were good. But the defense left out certain things in the Franks memo, which were bad for Rick. So what bad things did they also leave out? Well, I don't know. Love to hunt. What will you all think when anyone who wants him moved to a county jail and that is granted and the dude is found dead? What trial are you going to get out of that? As I said, I think he would be in whatever his cell for most of the day. I don't know. I would like the answer to that. Kevin says, if Nick is a reflection of the state's team that went before the Supreme Justices, Rick already has 1 foot out of the door. Wheat. They did hire James Luttrell. If you can call him Jim if you want, or Luttrell Sprewell. He's a former prosecutor, so Nick does have some help. And if you read people online, I'm helping Nick, which is not true at all. Georgia says they needed the rest of discovery, which Nick has not sent. He said he did send it by the November 1st deadline. They were falsely disqualified before then. That's true. Hi, Kirsten. You did not get a notification that I was doing a live chat, which is probably for the best. I was reading boring stuff for the first hour or so. Digital says they can't ask for a speedy trial and try to get the judge removed. She has 30 days to respond to the new filing. Well, they said, I think by filing it, that Gull should not be allowed to rule on anything until, I guess, this motion to disqualify is reviewed. But I don't know what the next step is. You'll have to watch other YouTube channels for that. 7 more minutes. And I'm 45 minutes behind. All right, let me skip a bunch. Danielle. Oops, sorry. If I wrote an email to Danielle, who would get it? I'm kidding. That's a reference to Baldwin. It just seems like there's a lot of drama from the state, and they're intentionally trying to cast Rick in his negative light as possible with the shackles, etc. And that's just bad for justice, in my opinion. Yeah, I don't know why he's in shackles and stuff. Is it because something that he did at Westville? I don't know. I know that the defense in one filing said that Rick, when he was being brought into jail, he kept saying something like, don't shock me, don't shock me, don't shock me, which, why is he saying that? When have they previously shocked him? Hi, Wampo, aren't you in France? So basically, both judge and defense should be replaced. I wouldn't be mad at that. But if Rick wants Baldwin and Rosie, then I guess give it to him if he's okay with the outcome. But my concern is if he's found guilty, is he going to say, oh, they were my friends until they didn't do a good job? I don't know. Wampo says Judge Judy would get this case done before commercials. We wish. Anne says, in my opinion, Indiana Supreme Court is going to have a heck of a time justifying in writing their quickie decision. Arguably, with all due respect, that was completely conflicted. Ari retaining Rosie and Baldwin and retaining Judge Gull. Well, they had time. They had like over a month to prepare for that hearing. So I'm sure because they knew it was such an important case that they did some preparation. Wampo, Tom's New Year's resolution should include getting less than an hour behind on chat. Yeah, I should do like 40-minute live chats. That way I can't get that far behind. What have we not talked about in the next 4 minutes? Digital, much respect that you can see positive and negative for both prosecution and defense. Justice for Abby and Libby. I do try to, I mean, people say I'm biased against the defense and whatever. I have not made a decision yet if Rick is innocent or guilty. Whatever I think about that, I'm not going to make a decision until the trial. And whatever I say negative about the defense has nothing to do with whether or not I think Rick is innocent or guilty. I mean, I try to show my reasoning for everything, and I do try and show as many different other opinions in this chat. You can't please everybody. Keith says, Rick is not going to speak out or say anything. And then he laughed. No decent lawyer is going to let a client speak to be taken out of context. That is the whole reason of an attorney to represent you. I've already said previously, if I'm falsely accused of murdering 2 kids, I'm speaking up. I don't care what my lawyers say. All right, I'm going to pick one final thing. Which one will it be? Which one am I going to do? I have less than 2 minutes. I have to stop at 2:59. I don't want to highlight anything. Thank you for people who wrote nice things about me, but I don't like to highlight those. What's the final one? I have 1 minute to choose something. Yeah, we'll do this one. Danielle says, all we should want is justice for the girls. Yes. And to get that, we need a judge who is not biased and who does follow the procedures, which I was convinced by, I would say, Baldwin and Rosie, that Gull has done some suspicious stuff and not followed procedures with getting these transcripts and not paying on time, which I don't know. I'm interested to see if Judge Gull is going to have some kind of response to this motion to disqualify, if there's going to be a hearing or not. Unfortunately, I'll probably be doing a live chats about it. So bye, everybody. I appreciate all of you, or at least most of you. Hopefully people were nice to each other. That's it for now. I don't know what else to say. I will have a new Delphi somewhat deep dive within maybe the next week. I'm supposed to work on it today, but unfortunately, these lawyers just keep filing stuff, and how dare they? All right, bye, everybody. I'll see you when I see you. Thank you for joining, and thank you to Gino, Metal Mama Michelle, and She Elf for your generosity. I appreciate it. All right, goodbye. Good night.